Hey, good morning. Welcome, everyone. This is our second hearing of the Peace Officer Standards Accountability Advisory Board. Today, before we get into the first order of business, I'm just going to make a quick announcement about the proceedings today. As many of you know, on the board, Ms. Dudley, our chair, will not be joining us today. Sadly, she would have been here if she could, but due to some unforeseen circumstances, she will not be joining us today. So I will go ahead and facilitate at least the first half of the meeting until we get to our cases that are before the board today. And then we will probably have our vice chair, as long as that person feels comfortable, facilitate the remainder of the meeting. Does that sound fair to the board members? Okay, great. All right, I'm going to go ahead and ask Chandler to call the roll this morning.
Okay, good morning, members of the board. Board Member Bushin. Board Member Clavo.
Present.
Board Member Crawford.
Present.
Board Member Doyle.
Here.
Board Member Dudley. Board Member Glaser.
Here.
Board Member Johnson.
Present.
Board Member Lara.
Here.
And Board Member Pena.
Here.
Okay, thank you. So we have a quorum. I want to thank those of you who are in attendance today. We want to take a couple of notes to kind of explain to you that this meeting or hearing is being webcast. It's also being recorded and transcribed. The microphones are on auto on and off, so you do not have to touch them before you speak. As soon as you begin speaking, they will go live. When you're not speaking, they will not be live. You will need to watch the crosstalk because if you lean over and talk to your partner, that'll be caught on recording and webcast, so just be advised. I also want to thank those in attendance today for joining us. When you are asked to come forward for public comment, you may introduce yourself and your association. You do not have to, so that is voluntary. I want to make sure that's clear today. I'd like to introduce some of the folks here at the table today. To my left, I'd like to introduce Chris Beatty. He's our board counsel. I'm Assistant Executive Director Anne Marie Del Manayo of the Peace Officer Standards and Accountability Division. To my right is Chandler Knapp. He works in EXO. Thank you. Okay, we're going to see if there's any public comment before the board today. This is the time that's set aside for members of the public who wish to comment on items that are not on the agenda, but those within the board's jurisdiction. Public comment on matters on the agenda will be heard after each item presented. Public comment specific to peace officer revocation cases to be heard today will be heard at the time of the hearing of each case. Please be advised that the board cannot take action on items not on the agenda, but only to the extent necessary to determine whether they should be made an agenda item at a future board meeting or to respond briefly to the statements or questions posed, request clarification, or refer the item to staff. Please remember that this meeting again is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so that the comment can be correctly captured in the transcript. I may ask members of the public to limit their remarks to no more than 3 minutes pursuant to existing board policy. I also may conclude public comment if multiple speakers are voicing repetitive or similar statements and our 15-minute public comment period has expired. Is there anyone present today in the audience or appearing remotely by phone who would like to address the board during the public comment? When it is your turn, you may state your name and organization only if you wish. Are there any public comments this morning? Okay, seeing none, we'll move on. At this time, I want to take a couple of minutes to do an administrative update for the board members. Again, this is a standing item that will appear on every board meeting, and it is simply to give the board members and members present today an idea of kind of where we are organizationally as a division, and also the volume of cases that we are currently managing. I believe we have a visual for you. We'll go ahead and go to the first page. All right, this is just an overview of where we are with the staffing for the division. We currently have about 13 full-time permanent law enforcement consultants that are working the cases, in addition to 14 retired annuitants that are law enforcement consultants as well. We're in the process of bringing on a couple of more. As you folks are aware, we did the in-person training on February 13th for the board and the commission. We've also had our staff attend, especially our law enforcement consultants and our division leaders and bureau chiefs, specialized regulatory investigator training. And that was really specific to administrative cases, what needs to be included in the investigation, how the report should be written, and how, of course, you substantiate your findings and report your findings to a advisory board or a governance board. Chief Counsel Toby Darden and I actually did some training for our administrative law judges from the Office of Administrative Hearings. We did that on March 14th. And that was essentially to give those judges that will be assigned the cases when they get to that administrative review, an overview of all things Senate Bill 2, the decertification process, the procedures, the types of cases they may see, and a little bit of insight into what we're finding in terms of the cases that are being submitted by law enforcement agencies. We sent out 6 notices of intent to revoke in mid-January. That resulted in the 4 appeals that are before you today. Since then, we've also sent out an additional notice of intent to revoke, and we have not received an appeal back. So as you folks know, we have a May hearing scheduled. Depending on whether or not we get additional appeals from those notices will obviously indicate whether or not we're going to have a May hearing. So I need to keep you apprised as to whether or not we have additional cases for May, or with whether or not our next hearing will be held in June, and we can kind of talk about that later. Next page. Okay, there's a couple of internal improvements that we've made, and one most significant is sending out the notice of investigation to subject peace officers. I think we talked about this a little bit during training, but what that has resulted in is an uptick in our voluntary surrenders. And so we're notifying the officers that post has received a sustained finding from a law enforcement agency regarding one of the 9 acts of serious misconduct. This is upon initial screening. So this is not where post has made any decisions about the veracity of the case in terms of bringing it before the board or the commission. We notify the officers that we are now investigating the case and what the sustained findings were by the law enforcement agency that submitted the case to post. Since January, we've received, and I think this number has changed since I wrote this, it's 11 voluntary surrenders. Prior to January, we might have had 4 or 5. So within the last 2 months, we've really seen an uptick in those based on that notice. We are also working on what we call disciplinary guidelines. Those are almost like what folks would consider a bail schedule in terms of what type of discipline may result in certain penalties. And it's based on obviously the severity of the act itself. It's based on the history of the officer and several other factors. But these disciplinary guidelines will be used to apply some level of consistency to the types of cases we see. They will also give instruction to administrative law judges regarding the imposition of discipline the commission feels is appropriate based on, the facts of the case. So we will be bringing those to the board once they're reviewed by the commission and we get some feedback from the commission. So if you folks can weigh in as well on those disciplinary guidelines. We hope to share those with the commission in June at their June 13th meeting. Right now, I want to take an opportunity to show you a really short video clip. This is a production that our team and the Learning and Training Resources Bureau put together for the field. And these are officers that are currently in the field, working peace officers. And really, it's an overview of what certification and decertification looks like after the implementation of Senate Bill 2. It's to provide some guidance and more factual information to the line staff who may not have ever had post inform them about Senate Bill 2 and all things certification and decertification. The actual video itself is 7 segments. It's about 43 minutes long, but we're going to show you a promo today so you can see the type of information. You will see there's a couple of us that are in the video. Ms. Clavo assisted in the video when we filmed the production of this, and we think it's turned out really well. We actually contract with a producing company who does all of the staging, puts together all of the lights, camera, action. So it doesn't look like a novice has done this. So I'm going to go ahead and have our team cue this up for you.
A new law has been passed in California establishing a decertification process for peace officers. As a former officer and a current trainer, I've seen firsthand the uncertainty and apprehension this law has sparked among the people I know and work with.
Regardless of how well you try to handle a call, there are times where complaints come through. That is unnerving when you're out working.
You're like, okay, I'm not gonna go out and look for things or pull over cars just in case, like, what if we make a mistake? Because we're human at the end of the day. And then we're gonna be held not only through IA, we have to worry about post clearing us as well.
In this series, we will unravel the complexities and real-world implications through discussions with stakeholders looking at it from multiple viewpoints.
We are now no longer passengers in this journey. We now must take more of an active role.
We had some of the same concerns when we first started using body-worn cameras. Most of the time, the camera has supported the actions of the officers. And so if they're aware of what those areas of misconduct are, they don't really have anything to worry about.
Process is there for a reason. It's there to ensure that your rights are protected. And if you're doing everything right, you're going to come out on top.
In a conversation with officers from across the state alongside post staff, members of law enforcement voice their concerns and search for answers from those who know.
There's questions as to what's going to qualify as serious misconduct. And I mean, can that change from reviewer to reviewer?
I've never seen like a hard definition as to what they're looking for.
That could cause a lot of stress and anxiety. Is there a definition of serious misconduct?
There is a definition of serious misconduct. Part of post responsibility, actually the post commission's responsibility, is to adopt a definition of serious misconduct.
We drill into the details through one-on-one interviews with post experts who are working these cases.
Passing SB 2 was another piece that personally now affects them. And I think that they all need to know what steps and what processes post is taking when we look at cases that are submitted. I think it's important for them to know that.
We're taking the case as it is, and we look at the underlying behavior, and we are stridently neutral. It helps the communities to have some voice into the process. I think it's one of the strengths that gives post its ability to be trusted in moving these cases forward.
Engaging directly with post executives and board members, we hear their perspective on how they think this legislation came about and what they have done to prepare for the impact this has on both law enforcement and the community.
Your hairstylist can lose their license, a doctor, a lawyer. When it finally dawned on somebody that there was no way to decertify a peace officer, that was kind of mind-blowing.
I think that's what the community is looking at, is that they're being held to the same standards. They don't want to see them being able to lose their job here, but then be hired at another agency.
It's about integrity. It's integrity in the profession and integrity in the process. Trust in the fact that we understand we're dealing with individual lives and livelihood.
The changes in certification and decertification have illuminated more than just a procedural shift. This journey is not just about a new law, it's about re-examining our commitment to the community, law enforcement, and each other. Watch this post-on-scene investigative series now.
Okay, so that's just kind of a promo or a preview to what the full video will look like. And again, that's intended to roll out to the field. We anticipate making that a required continuing professional training for law enforcement officers in the future. Right now, we're going to roll it out and we're going to have them pilot this in, the law enforcement agencies. We're also working on an academy video that will explain certification, decertification for recruits that are in the academy so that before they ever start their career, they have a fair understanding of their relationship with post, which has changed substantially since the implementation of Senate Bill 2. Any questions about the video or comments before I move on?
Video already up on the portal?
No, not yet. We're getting ready to release it. We want to make sure that the commission and the board we were able to show you the promo. Anything else? Okay. Great. Next page, please. All right, this is just a kind of overview of our current statistics within the Professional Conduct Bureau. So again, just to explain, agency misconduct reports, there's a lot of them. There's over 22,000 agency misconduct reports. Those aren't necessarily cases. Those are reports that have come in. Sometimes there's multiple reports about one incident. But I think what's notable here is 69% of those are retroactive cases. So those date back from January 1st, 2020 to January 1st, 2023. One statistic that we've been asked to include is how many officers are involved in these cases. So here you'll see there's 14,940 officers. 550 of those came from public complaints, not from law enforcement agencies. Another extremely notable statistic here is upon initial screening, a small number of these cases actually result in a substantiated finding or a finding of serious misconduct by clear and convincing evidence. And so to put this into perspective, right now we're looking at probably 8% of those cases may, after thorough review, result in some sort of proceeding. And that again tells a different story, right? 22,000 is a huge volume of cases. But when you look at the actual number of cases that we consider meritorious at this point based on what was submitted, we're looking at about 8%. There are 10,327 cases that are opened. Again, you'll see here, about 5,500 are open with posts. The others are opened with the law enforcement agencies, meaning we received them as a complaint charge or allegation, and they're still completing their internal affairs investigation. So it's not complete at the law enforcement agency level. We've closed about 5,200 cases, 5,300 cases, which is 34% of that total number of 10,000 cases, or excuse me, 15,000 cases. Many of those cases are the retro non-actionable. So they did not fall within one of the three categories that we could take action, which is use of deadly force resulting in serious bodily injury or death, dishonesty, or sexual assault. Those were the only three acts of serious misconduct that we could take action on prior to January 1st, 2023. So majority of those cases fall into the other categories. And then again, the top three areas of alleged misconduct is excessive use of force, demonstrating bias, and abuse of power. Any questions from the board on the statistics? Yeah.
What is the percentage of cases that don't apply to SB2? I know at one time.
Non-jurisdictional?
Yes.
Very few. We do have a percentage of those cases. I don't have the stat in front of me, but I can bring that to the board at the next hearing. The reason I know it's very few is we just prepared a report to the legislature, and it's an annual report. In Penal Code Section 13.512, the legislation spells out an annual report with various statistics that will need to be submitted every year. One of those statistics is kind of the disposition of the cases from the law enforcement agency submission. So what happened, right? Was it exonerated, unfounded, sustained, or upon review, did we send it back because it was a non-jurisdictional case? So there's a small percentage that we receive that just don't fall into one of the 9 acts of serious misconduct. What we see more of are cases where I think the agencies are attempting to maybe shoehorn them into one of the 9 categories, but it's a failure to act, a failure to supervise, a dishonesty case that doesn't meet the very specific definition in SB2. So the agency may label it dishonesty, which upon initial review is one of the 9 acts of serious misconduct. But if you look at the dishonesty definition, it's very narrow. And so the type of dishonesty that's submitted may be non-jurisdictional. So we do get those cases. and I can bring that statistic back. Any other questions?
I just have a clarification.
Sure.
On the second big bullet point there, the context one. When it says after triage, around 5% appear to have potential merit for decertification, is that 5% of those that have passed through triage or 5% of the total?
So the triage, that's 5% of the total after triage, right? So triage is essentially not, we don't like it or we like it. Triage is, these are sustained findings. Which of these sustained findings are going to move, do we think are going to move forward for a thorough investigation and potentially a hearing before the board and the commission? Yeah.
And the 5% is among those.
Right. Correct.
Okay, so it's getting smaller and smaller.
Right.
Okay,
Right.
thank you.
Thank you for clarification. All right. Are there any comments from the public regarding the report? Yeah. On to the next item. Okay, so as you know, at our very first hearing on December 14th, the board took a look at two specific cases. Both cases involved acts that violate the law, very different cases. And I'm sure as you recall, the decision of this board was revocation on both counts. The commission reviewed both cases on March 7th at their commission meeting. In the matter of the Ramirez case, the commission upheld the revocation. That was the Justin Raymond Ramirez case, post case number 23-08479. So the commission agreed with the recommendation of the board and moved the case for revocation. So that case will now, if the individual is interested in appealing, would go to an administrative hearing, a full evidentiary hearing before an administrative law judge. So there will be an accusation filed. We work with the Department of Justice and their licensing section to file the accusation on behalf of Post. The individual will be given a 10-day notice of defense to file in response to that accusation. If the individual does not file a notice of defense, the revocation will be the default order, and we will advise you accordingly. In the matter of James Kurtz Fillmore, post case number 2303691, the commission voted to adopt settlement terms. Those terms have not been ironed out to this date. The division is working with our attorney, Chris Beatty, who is also the attorney for the commission and all of the case matters before the commission. We will be presenting what we think they would like to see in terms of settlement terms at their June meeting. And if those settlement terms are adopted, I will report back to the board what those settlement terms are. If their legal counsel does not agree to those settlement terms, the default in that case or the alternative would be revocation. So there's more to come on the Fillmore case. Is there any questions?
Hey, anything more about that? I know there are probably limits to what you can say, but what kind of settlement might we be talking about?
So because the commission hasn't agreed to those terms, I can't publicly describe the nature of those terms. I can tell you that part of the discussion is the division's ability to operationalize those terms. So as you folks may know or may not know, and I'll describe it here for you today, we don't have a probationary unit. So there's not a workforce here at Post that is designed to monitor someone's compliance with settlement terms. So there's some discussion on the operational side of things is how will we monitor any settlement terms that come before the board or commission, even into the future. And we're working those things out right now. Until such time that I can give you a confirmation, I can't say much. I apologize. Yes.
There's an echo, the
Yeah.
sound, there's an echo and it's a little hard to hear every now and then.
If I stay away from the mic, does that help?
Bouncing off the walls and then.
Oh, okay. I'll try to sit back. Maybe it's me. It's possible.
Thank you.
You're welcome. Any comments, public comments regarding the cases that have been heard before the board and now the commission? Okay, seeing none, we will move on. Okay, it is now time for us to decide on the nomination of a vice chair for the Peace Officer Standards Accountability Advisory Board. As most of you know who've served on governance boards, the vice chair's job and responsibilities may vary. For the most part, they're here to sit in for and substitute for the chair in the chair's absence. A vice chair may also be assigned such duties as overseeing a task force or a subcommittee of the board for very specific purposes that the board may delegate to a subcommittee, whether that be audit functions, research, etc. So at this point, is there anyone present who would like to, well, I should say, are there any nominations for the vice chair? Board Member Pena.
I just want to make a comment before we nominate, before there are nominations, that I really personally feel that the vice chair should be someone from the non-law enforcement side of the board. I think the legislature made this board balanced, and I think that balance should be reflected in the chair and vice chair. Thank you.
Any other comments? Okay. Nominations.
I would like to nominate Mr. Robert Doyle.
Mr. Doyle, do you accept that nomination?
For what?
Accept that nomination? Okay. Others? Ms. Pena.
I nominate Regina Hatcher Crawford.
Crawford, do you accept that nomination?
Yes, I do.
Okay. Do I have any others?
I'd like to nominate Nicole Clavo.
Slavo, do you accept that nomination?
I'll pass.
Okay, thank you.
Thank you, sir.
Any further nominations?
I'd like to nominate Board Member Johnson.
Okay. Mr. Johnson, do you accept that nomination?
I'd like to pass also.
Okay. Good news is you all seem to like each other, so that's helpful. Do I have any additional nominations? Okay. So I'm going to take these in order as they were called. I think our first nomination was Mr. Doyle. Do I have a motion to elect Robert Doyle as Vice Chair of the Peace Officer Standards Accountability Advisory Board? Right, you can make a motion, yes.
I make a motion.
Okay. Clavo moved. Do I have a second? Thank you, Mr. Johnson. Hey, Mr. Knapp, will you call the roll?
Yes. Okay. Board Member Buchan. Board Member Clavo.
Aye.
Board Member Crawford.
Nay.
But, yeah.
Yeah,
Abstain or nay?
nay.
Okay.
Board Member Dudley. Board Member Glacier. Board Member Johnson.
Yes.
Board Member Lara.
Aye.
Board Member Pena.
Abstain.
Board Member Doyle.
Okay, so we have 4 yeses. I think we have 2 noes and 1 abstention. So I believe that motion passes, 7 members present. Okay, so Mr. Doyle, congratulations. You are the vice chair of the Peace Officer Standards Accountability Advisory Board. The reason we don't call the second and third is because we had a motion that passed. Okay, thank you very much. All right, so we are now going to move, I'm sorry, is there any members of the public that wish to comment on this matter? Oh, we have caller on the line. Standards accountability. Reason we don't call the second and third. Go ahead, caller. Did you have a public comment?
I'm waiting for the David Hubbert agenda.
Oh, okay. We're going to take that up shortly in the cases. So we're not quite there yet, but thank you.
Nope.
Any other comments, board, public? Okay, what I'd like to do now, because that completes kind of the administrative business of the hearing today, before we move into the cases, is we are going to take a quick 10-minute break. The vice chair. Oh, I'm sorry. I'm missing something. I apologize. I'm getting ahead of myself. I'm anxious to get to the cases clearly. We need to review the transcripts from the last meeting. So let's do that order of business first, and then we'll take our break. Okay, so at this time, we'll go ahead and take an approval of the meeting minutes from the December 13th, 2023 meeting and the meeting transcript from the December 14th, 2023 board hearing. Any discussion before we have a motion on either set of transcripts? Okay. Does anyone have a motion to accept both the December 13th, 2023 minutes and the minutes from the December 14th hearing?
Motion to accept.
Thank you. Laura? Second?
Second, Doyle.
Doyle? Thank you. Okay. Public comment on the transcripts or minutes from the 2 dates? Okay, seeing none, Mr. Knapp, can you call the roll?
Board Member Buchan. Board Member Clavo.
Yes.
Board Member Crawford.
Yes.
Board Member Doyle.
Yes.
Board Member Dudley. Board Member Glacier.
Yes.
Board Member Johnson.
Yes.
Board Member Lara.
Yes.
And Board Member Pena.
Yes.
Motion carries. Thank you very much. Now we will take a 10-minute break. And we will have our vice chair take over facilitating the meeting for our cases. Okay, so we will reconvene at 9:45. Thank you. And call us back to order. We're a little behind here. Good. Okay, we are back on the record. Okay, now is the time of the agenda where we're going to hear new cases that are before the board to discuss whether or not decertification or some form of suspension is appropriate in these cases. I'm going to read some introductory statements before I turn it over to Vice Chair Doyle to introduce our cases. We have 4 cases to hear today. We will only be reviewing the facts and evidence as presented by this division. This is not an evidentiary hearing. The rules of evidence do not apply here. Evidence is not formally admitted into the record. There is no need to make any objections, and objections will not be ruled upon. Under the Penal Code and applicable state regulations, this initial hearing will determine only if the matter will proceed forward for commission review, and then, should the commission approve, for a full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justify discipline. For those commenting on each item, at this early stage, the board must only consider the facts the division, after investigation, believes can be proven at a later evidentiary hearing. For that reason, today the board will entertain arguments as to whether or not those facts, as presented by the division, demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Regulation 1205 have occurred. This finding results in the matter being moved forward. No actions by the board or the commission prior to the full evidentiary hearing amount to a final determination that the officer did in fact engage in serious misconduct, or that the revocation or suspension is ordered. That will be determined after the evidentiary hearing. At the conclusion of the law enforcement consultant's presentation before the board will have an opportunity to ask questions. Then public comment from the subject officer and/or their counsel will be taken, followed by members of the public. Further discussion by the board will be allowed if necessary. The board has several options before them today. The board may go into closed session to deliberate after each case, or the board may wait until all cases have been presented and adjourn into closed session to deliberate all cases at the end of the hearing. After reconvening into regular session, votes will be taken on each case. With that, we will now dive into our first case of the day. I do want to remind the board members, closed session is optional. If the board is ready and willing to take a vote or a motion on a case without having to go into closed session, that is also an option before the board. So I just want to reiterate what I just read, because I read a lot. The first option is the board may go into closed session after each case if it feels as though they need to seek the advice from legal counsel or deliberate some of the facts with legal counsel that were presented at the time of the case presentation by the law enforcement consultant. The board may wish to discuss the case in open forum and take a motion and vote without going into closed session after each case, or the board may hold closed session to the end of all 4 cases being heard in open session. Just want to make sure, does that make sense to everybody before we move into the cases? After the presentation, Vice Chair Doyle will kind of lead you into which option seems to be, most appropriate given the case that you've heard. Are we ready? Okay. I'm going to turn it over to Mr. Doyle.
Thank you. First case is Cesar Diaz, post 2311496 and post ID C68U20. At this time, I will call upon law enforcement consultant William and Baldwin, Professional Conduct Los Angeles Bureau, and Carrie Woodley, attorney for Legal Affairs Bureau, to provide a report on case post 2311496. Cesar Diaz, with the time of the events at issue in this case, was employed by the Los Angeles School District Police Department.
Thank you, Mr. Vice Chair.
Speak.
My name is William M. Bowden. I'm a law enforcement consultant 2 in professional conduct assigned to the Los Angeles County Bureau. Beside me is Carrie Woolley, an attorney with the Legal Affairs Bureau. The case before you, post 2311496, was submitted to post for an allegation of serious misconduct under California Penal Code Section 13510.8B6, acts that violate the law. That states that acts that violate the law and are sufficiently egregious or repeated as to be inconsistent with a peace officer's obligation to uphold the law or respect the rights of members of the public as determined by the commission. In June 2020, Cesar Hazel Diaz, an officer with the Los Angeles School District Police Department, while off duty, was arrested in Orange County, California for suspicion of
In June 2020, Cesar Hazel Diaz, an officer with the Los Angeles School District Police Department, while off duty, was arrested in Orange County, California for suspicion of driving under the influence of alcohol. Mr. Diaz was seen driving his vehicle recklessly at a high rate of speed, approximately 50 miles per hour in a 25-mile-an-hour zone, on the wrong side of the road and crossing over solid double yellow lines with several passengers in his vehicle. Mr. Diaz failed field sobriety tests and was subsequently arrested. When he was taken into custody, his loaded handgun was located in the waistband of his clothing. During the booking process, Mr. Diaz provided a blood sample to determine his blood alcohol concentration, which ultimately returned as 0.14% BAC post-arrest. Just 10 weeks later, in August of 2020, while driving his vehicle off-duty in Los Angeles County, Mr. Diaz was seen rapidly accelerating as he exited a parking lot and swerving across 4 lanes of traffic in one move without signaling. After stopping at a red light, Mr. Diaz then accelerated rapidly while crossing 2 lanes of traffic to make a right turn without signaling. During the subsequent DUI investigation, it was discovered Mr. Diaz's loaded firearm was on the floor under the front passenger seat, which was occupied by a subject who was not a peace officer and who also had been drinking alcohol. While being booked at the jail, after being arrested, Mr. Diaz provided breath samples to determine his blood alcohol concentration. The sample showed Mr. Diaz's blood alcohol concentration was 0.17% and 0.19% shortly after his arrest. In July 2021, in LA County Court, Mr. Diaz pled no contest to 1 misdemeanor count of driving under the influence of alcohol with BAC of 0.08% or higher. The second misdemeanor charge was dismissed as part of the plea bargain. In October of 2022, in Orange County Court, Mr. Diaz pled guilty to 2 misdemeanors, driving under the influence and driving under the influence with a BAC of 0.08% or higher. Mr. Diaz's employer told the administrative investigation while the criminal cases worked their way through court. Due to the court delays, the June 2020 arrest was not cleared administratively until December of 2022. At the conclusion of the administrative investigation, Mr. Diaz was suspended without pay for 240 hours by his agency. As a result of his actions, Mr. Diaz was arrested twice in a 10-week span for driving under the influence of alcohol. At the time of his second arrest, his blood alcohol concentration was significantly higher than the first time. During both arrests, he exhibited erratic and dangerous driving behavior, putting both his passengers and the rest of the driving public at extreme risk of death or serious injury. Additionally, he was in possession of a loaded firearm both times. The second time, his firearm was unsecured and accessible by an inebriated passenger. Based on these actions and the details as I have described them, the division believes there is clear and convincing evidence that Mr. Diaz committed serious misconduct as defined in section 13510.8B6. For the purposes of this report, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. That's the end of my report, and I'd be happy to take questions.
On the first DUI, there was no weapon found?
There was a weapon in both DUIs. The first DUI was in his waistband.
A question by board members? No. This time, does the subject officer or their counsel wish to make public comment? You may state your name and organization if you wish. Please come to the
Hello, Madam Chair and Vice Chair and board members. I prepared a 3-minute speech because I know I was told I only had 3 minutes to speak about myself. So my name is Cesar Diaz. Thank you for allowing me to speak a little bit about myself today. I ask that while you consider my case, that you also consider the facts about what I have done to learn from my mistakes and how growing from those mistakes have made me a different person and a better police officer to this day. There was a period of time in 2020 where my actions did not correctly reflect my true character. I was dealing with undiagnosed PTSD, unmanaged grief from family and work losses, the 2020 riots in Los Angeles, childhood trauma, and unfortunately, my list of coping skills only included drinking. After my off-duty mistakes, I realized what I was doing to cope wasn't working. I made the conscious decision to work on my personal and mental wellness by choosing to attend a 30-day inpatient rehab for first responders. After that, I also completed a 90-day outpatient program where I received continued support for my personal wellness to this day. I have found since then new and healthy ways to cope with my PTSD that don't include drinking. I learned how my coping skills were detrimental to me and negatively affecting those around me, like my family, community, and friends. Today I stand in front of you, a better man with a long list of healthy coping skills. I recently become a father, which has shaped my world for the better and created a why for me every day. With my new coping skills, I have been able to successfully manage duty-related traumas as I have continued to work in the field as a police officer and having dealt with personal losses for the last 4 years. I love my job as a police officer. It affords me the opportunity to serve people on their worst days, including people who have made similar mistakes to what I have made. It allows me to positively impact my community and to help set an example of how one can overcome their mistakes and increase their overall wellness and be able to lead a better life. With all that said, I understand the need for accountability in peace officers, and I commend your service for these efforts. I hope that you can see how my actions after my mistakes reflect my integrity and how I have held myself accountable for my family and my community that I serve. Thank you for allowing me to represent myself and speak about who I am. If you have any questions, I can answer in regards to my case.
Board members, any questions? No? Is there any public comment to the presentations? Thank you. At this time, is it the board's interest in going into closed session after each case, or take them all at the same time?
I move that we go into closed session now.
Okay.
Yeah.
I second.
Okay. At this time, the meeting will adjourn into closed session for deliberation. Okay, we will now reconvene to the regular session to take a vote on the board's recommendation to the commission. As a reminder to the board has several options in making a recommendation to the commission, including a suspension, revocation, or no action. Each option is available until a motion is voted on and approved. In other words, if a motion to revoke certification is made and passes, that ends the deliberations. If such a motion is made and fails, however, a motion to suspend certification may still be made should any board member wish to do so. In the matter of the case post 2311496, Cesar Diaz, who at the time of events was at issue, was employed by the Los Angeles School District Police Department. What comments do members of the board have to make on this matter? None? Okay. Is there a motion by the board to make a recommendation to the commission?
I'd like to make a recommendation, please.
Commissioner Lara?
I recommend that a period of 6-month suspension.
Second. The second by Mr. Glasser. Roll call.
Board Member Bushin. Board Member Clavo.
Aye.
Board Member Crawford.
Aye.
Board Member Doyle.
Yes.
Board Member Dudley. Board Member Glacier.
Aye.
Board Member Johnson.
Nay.
Board Member Lara.
Aye.
Board Member Pena.
No.
Three yeses, one abstention, and 2 nays.
Motion passes 4 yes, 2 nay, 1 abstention. Okay, motion passes. Next case will be the post 2300809 Dylan Houston, post ID C71-S10. At this time, I will now call upon law enforcement consultant Mark Nagel, Professional Conduct Southern Bureau, and Chris Becker, Assistant Chief Counsel, Legal Affairs Bureau, to provide report on case post 2300809, Dylan Houston, who at the time of the events and the issue was employed by the San Diego Police Department.
Good morning, Vice Chair, members of the board. My name is Mark Nagel, and I am one of the law enforcement consultants assigned to the Professional Conduct Bureau South in the Peace Officer Standards Accountability Division. With me today is Chris Becker, an attorney with our Legal Affairs Bureau. I am here today to present case 2300809 involving Officer Dylan Houston, currently with the San Diego County Sheriff's Office. It is the division's determination that clear and convincing evidence exists to demonstrate that Officer Houston committed an act of serious misconduct as set forth in Penal Code Section 13510.8 on April 10th, 2020. Specifically, the division has determined that Officer Houston committed dishonesty as described as serious misconduct. In this presentation, I will present a brief outline of the division's findings of investigation in this matter, along with supporting slides and a shortened clip of the body-worn camera video. On April 10th, 2020, Officer Houston and a partner responded to a call of a domestic violence incident. While on scene, Officer Houston used force on the male suspect on 2 separate occasions. The force used by Officer Houston on these 2 separate occasions was found to have violated the San Diego Police Department's use of force policy. Next slide, please. As on the slide, any action by posts relating to the uses of force, however, are not actionable by statute because the date of the incident predates the implementation of Penal Code Section 13510.8B3. However, the facts relating to the force used by Officer Houston are relevant to support the dishonesty, which is covered under Penal Code Section 13510.8B1 and G1A. Those facts are incorrectly stating the amount of time the suspect was unconscious, incorrectly stating the suspect was guided to the ground, falsely stating the suspect had access to immediate weapons, stating he used distraction blows to secure the suspect's arm while pausing a half second between each strike. Before addressing the facts of the matter at issue today, I would like to bring to the board's attention that the investigative summary of findings submitted to the board is an amended version. An original investigative summary of findings was issued to Officer Houston on October 13th, 2023, addressing the division's findings that he was dishonest in the reporting of his applications of force. The division conducted a subsequent review of the facts of the case and noted additional findings related to Officer Houston's dishonesty surrounding the reporting of his applications of force. An amended investigative summary of findings, which you have before you today, was then sent to Officer Houston outlining the original and additional findings, and he was provided with an additional 30 days to appeal. At the time of events at issue, Officer Houston was employed as a peace officer with the San Diego Police Department. On September 22nd, 2022, he resigned from the San Diego Police Department and is currently employed as a deputy sheriff with the San Diego County Sheriff's Office, effective September 23rd, 2022. Officer Houston holds a basic and intermediate certificate. In this case, the division concluded that Officer Houston committed 4 instances of dishonesty used to mitigate his actions and the extent of the suspect's injuries stemming from excessive use of force on April 10th, 2020. First, Officer Houston stated on multiple occasions the suspect was unconscious for 2 to 3 seconds. For example, Officer Houston stated the following in his criminal report, quote, While guiding the suspect to the ground, he fell awkwardly due to his level of intoxication and struck the side of his head on the ground, causing him to lose consciousness for approximately 2 to 3 seconds. However, our investigation found Officer Fooston's reporting of the time when the suspect was unconscious to be dishonest based on the following. Officer Fooston keyed his radio and asked dispatch to send medics 11 seconds after he hit the ground. 48 seconds after the suspect hit the ground, Officer Fooston keyed his mic and advised the suspect lost consciousness for 2 to 3 seconds. 1 minute after the suspect hit the ground, Officer Fooston gave the suspect a sternum rub and told the suspect to wake up. 1 minute and 5 seconds after the suspect hit the ground, Officer Fooston checked the suspect's pulse. 1 minute and 47 seconds after the suspect hit the ground, Officer Fooston checked the suspect's pulse while the suspect could be heard snoring. 2 minutes and 58 seconds after the suspect hit the ground, the suspect moved his head for the first time. During Officer Fooston's investigative interview, he said he observed the suspect snoring and saw his eyes flutter as a sign the suspect was conscious. Officer Fooston clarified his statement and said he misspoke. He said his time assessment was wrong when he said the suspect was unconscious for 2 to 3 seconds. Officer Fooston stated, quote, "The suspect was alive, but as far as awake and alert, no." Officer Fooston asked if he was accurate in his report. To this, Officer Fooston responded, "No, I think it's pretty clear." Second, Officer Fooston's statement that he held onto the suspect's body with both hands to guide the suspect to the ground. Specifically, in his criminal report, Officer Fooston stated the following, quote, "I knew that the suspect was in handcuffs and was unable to control himself during the fall, so I held onto his upper body with both of my hands to guide him to the ground where he could no longer kick me." However, our investigation found this statement to be dishonest based on the following. As seen in the video footage, the suspect was intoxicated and handcuffed. Officer Fooston swept the suspect's legs out from under him without a plan for protecting the suspect from harm. Indeed, Officer Fooston's left hand was on the suspect's left arm, and the suspect fell to the right, making it unlikely his left arm would help control the suspect to the ground. The suspect's head was not controlled, resulting in the suspect's head colliding with the concrete floor. Third, Officer Fooston's statement that the suspect had immediate access to a weapon while lying on the bed was not supported by articulable facts. Specifically, Officer Fooston said the following in his criminal report of the incident, quote, "The suspect forced his left hand underneath him towards his waistband. Knowing that I had seen several large knives in the apartment and that they were spread out randomly throughout the apartment, I feared there may be another knife in the bed with the suspect. I also had not been able to check if the suspect had a weapon on his person." However, our investigation found this statement to be dishonest based on the following. There was no mention of a weapon in the initial call. The reporting party did not mention weapons. A knife on the table was no longer in reach of the suspect once the table was moved by the officers. Officers did not check the bed for weapons prior to waking the suspect. Officers had a clear view of the suspect's hands for several seconds. The suspect was not padded for weapons until he was taken outside. Neither officer mentions weapons in their reports besides the knife on the table that was moved away. Fourth, Officer Fooston stated in his investigative interview that he used distraction blows to secure the suspect's arm while pausing a half a second between each strike. Specifically, he said, quote, "I executed distraction blows in order to basically get him to comply with our commands, as well as get his arm up." However, our investigation found this statement to be dishonest based on the following. Distraction blows target the lower body and are defined by San Diego policy as open-handed, lesser controlling strikes using a lower level of force. Officer Fooston used a closed fist to deliver 6 full force punches to the suspect's upper back. resulting in fractures to multiple ribs. The injuries sustained by the suspect are not consistent with distraction blows. The use of a closed fist strike as distraction technique is not authorized per San Diego Police Department Policy 1.04. Officer Fooston said he believed the suspect was armed with a weapon. However, he could not articulate specific articulable facts to support his belief that the suspect was armed or had immediate access to a weapon at the time he punched the suspect multiple times. So Penal Code 13510.8C5 provides that the commission shall consider a peace officer's prior conduct, discipline, and service record, and any prior instances of misconduct, including any incidents occurring beyond the time limitation for investigation in evaluating whether to revoke certification for the incident under investigation. To the division's knowledge, there are 3 prior claims against Officer Fooston alleging excessive use of force. They are as follows. October 27, 2019, while employed by the San Diego Police Department, Officer Fooston responded to an intoxicated male. The suspect resisted arrest by pulling away from the responding officers and attempted to evade arrest. The suspect was subsequently arrested for narcotics possession and resisting arrest. A complaint by the suspect was made alleging excessive use of force against officers. The allegation was investigated and determined to be not sustained. December 14th, 2019, 4 months before the event we are speaking on today, San Diego Police Department officers, including Officer Fooston, contacted a subject who matched the description of a person wanted for vandalism. The subject did not comply with commands and physically resisted officers. Officer Fooston subdued the suspect by applying a carotid hold. The suspect alleged Officer Fooston used excessive use of force. San Diego Police Department subsequently conducted an investigation into Officer Fooston's actions that day and determined that he violated their use of force and carotid restraint procedures when he applied a non-departmental approved or modified carotid restraint or neck restraint, and when he exceeded the carotid restraint duration hold for 15 seconds. As for the excessive use of force claim, Post closed this matter as a non-actionable because the events took place in December of 2019, prior to the January 1st, 2022 effective date of Senate Bill 2 and Penal Code Section 13510.8B3. It is our understanding that the victim in this matter filed a civil lawsuit in San Diego Superior Court on July 2020 against Officer Fooston, the officers involved that day, and the city of San Diego. The lawsuit asserted, among other claims, that Officer Fooston used excessive and unreasonable force against the victim and recklessly administered a chokehold against the victim. This case was removed to federal court and reportedly settled in January of 2024 for $875,000. While this use of force in this matter was determined to be not actionable by Post under SB 2, it is particularly noteworthy because it occurred 4 months prior to the events in question, and in our opinion, likely impacted Officer Fooston's state of mind, played a role, and provided motive in Officer Fooston's dishonesty in reporting the use of force in this case. On October 20th, 2022, a complainant alleged she suffered a facial fracture and numerous body wounds resulting from an encounter with San Diego County Sheriff's deputies, which included Officer Fooston. The use of force was determined to be within department policy and law and was found to have been justified. This case was referred to Post and is currently pending review. The facts I've just recited support the division's finding that Officer Fooston was involved in serious misconduct, specifically dishonesty. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish the fact beyond reasonable doubt. The division recommends that Officer Fooston's post certificate be revoked. The division's recommendation is based on the following. Police legitimacy reflects the belief that police ought to be allowed to exercise their authority to maintain social order, manage conflicts, and solve problems in their communities. Public trust and confidence in the police involve the belief that the police are honest. That concludes my opening statement. Prior to today's hearing, the board was provided with a full video from the Officer Fooston's body-worn camera showing the events in question. I have taken that video and clipped it to a more condensed version, outlining the more relevant events demonstrating Officer Fooston's use of force and dishonesty. At this part of the presentation, we will show the condensed version of the video.
You want to just stay out here, man?
Yeah, we're gonna get him. We found this. A friend we were with believes this is like the holy grail of World War I helmets, and that's why I called you up and hoping you could tell me. Well, most people only think the Ford built cars, but when World War I
Chris.
started, the very first thing we made wasn't a car, but a boat. We made a boat.
Hey, Chris.
So we made 60 of them. We also made an awful lot
Chris.
of helmets. So the one
Chris.
that we made almost 1 million of was your typical
Chris.
English Tommy Boy helmet. And this is supposed to be the super rare experimental ones. There were two types of experimental ones. Type 2, which looked like your typical
Come on, check his pulse.
And then the Type 8 helmet.
Hey, Chris, what's going on, man? San Diego Police Department. Okay.
You're what?
You're allowed to be drunk in your house. Okay. Hey, Chris, we need to get your statement, bud. Huh?
Get over here.
Okay. Hey, bud, you want to get up for me?
They're doing what they're doing. They're trying to act like they're fucking in trouble. See what they're doing?
Come on.
See what they're doing here? They're acting like they're touching me. See what they're dragging me? See? They're dragging me. See what they're doing here? They're dragging me. Look at them. They're dragging. They're literally dragging me. Dragging me. Look at them. Look, they're drug addicts. I'm doing nothing, but they're drug addicts. Look at them. They're jumping on. Look at them. Look at them. Jumping on.
Give us your arm. Give us your arm.
That hurts.
Give us your arm.
That hurts.
Give us your arm.
Ow, that fucking hurts.
Give us your arm. 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 Give us your arm.
You're too late. You can do it, Joel. You can do it.
I didn't call.
You my friend?
But I'm still your friend.
You see what they did? You see what they
But I
did?
don't want to talk to you ever again.
What did you say?
I don't want to talk to you ever again. Don't call me or nothing.
Oh my God.
No, I'm tired of it.
What did you say that for?
Because I'm tired.
Get up.
I give up. Thanks a lot.
Walk this way.
I give up.
It's not
I give
me.
up. I give up. I give up. I give up. I give up, guys. I give up. That hurt.
Okay. Do you just want to get all of her information and then I'll hang out with him?
I understand. I understand. You have to do this kind of thing. I know that. That hurt, Joanne. That hurt. Thanks a lot, buddy. Just turn me over, God. What are you doing? What? Is all right? You turn right now?
Nope.
Joanne! Wake up. Man, that hurt. You put me in the fucking rib, man. Come on. You feel proud of yourself? Are you feeling proud of yourself? I'm ready back to do it. Joanne, help me.
Stop.
Hit me in the ribs again, motherfucker. Hit me in the ribs. Hit me in the fucking ribs again. Stop. Hit me in the fucking ribs again. Stop. You chicken motherfucker. You're a chicken shit. You're a chicken shit. You know it. You fucking take fucking easy punches. You take easy punches. You're an easy punch maker. You're an easy punch maker. Ow.
Stay on the ground. Stop. Do not try to kick me. Do not try to kick me. Yeah, I'm gonna need an ambulance. 521 Victor, I'm gonna need 1141. Subject trying to kick me, took him to the ground, he hit his head.
I don't want him back here.
He's handcuffed, he was just trying to kick me while he's handcuffed, so I just need 1141, room 714. Loss of consciousness, 2 seconds. Wake up, Chris. Wake up. Just get her pulse in and I'll stay with him. And for fire, conscious breathing, 59-year-old male. Chris, wake up, bud. Wake up, you're okay. You just tried to kick the police. Shouldn't do that. Which room do you live in, ma'am?
All the way down there. I can wait.
You can
Not a problem.
come on through.
You sure?
Yeah. Chris, wake up. Wake up, bud. You all right, buddy? You feeling all right? Come on, stay awake. Breathe with me, Chris. You're gonna be all right. Just relax for me, okay? You gotta stop trying to fight me. You're under arrest, okay? Cause you, okay? I know, because you wouldn't give us your hand. I thought you had a weapon, okay? You were talking to cops. You gotta do what we say, bud.
We're going to pause it there. The video does not show any more examples of uses of force. Just want to be mindful of your time this afternoon. We can continue playing or we can bring it back to the board and we're happy to answer any questions if you would like.
Board have any questions? No. Also for the audience, Mr. Lara excused himself from this case because he's a member of the San Diego Police Department and he left the room before the presentation. So thank you. Mr. Fuston has forwarded to post written statements reported to him from members of the public, the statements regarding his character, division in making time available to you with the following caveats. At this stage of the proceedings, the only issue for the board is whether or not the division's investigative summary and findings provides clear and convincing evidence of serious misconduct. The division's position is that character statements of this kind are not relevant to this inquiry and might be provided, if at all, only during a later evidentiary hearing. In excess of caution, however, staff will provide the letters to you as public comment, keeping in mind that we did not receive them directly from those members of the public. And again, keeping in mind that the board's ultimate task is to determine the sufficiency of the division's investigative summary and findings. At this time, does the subject officer or their counsel wish to make a public comment?
I do. Can you hear me?
Yes.
Okay.
Please state your name and organization if you wish.
Thank you. Good morning. My name is Bradley Fields from the law firm of Bobbitt Pinkerton Fields, counsel for Dylan Fuston. May I proceed?
Yes, please.
Thank you. Dishonesty is intended to cover intentionally and knowingly making a false statement. Instead, the commission is using suspicions, inaccurate descriptions, and incorrect understanding of medical terminology as the basis for decertification. If that's the case, any mistake by an officer could be used as the foundation for decertification, and that certainly can't be the case. With regard to the first allegation, as stated in the report, the commission incorrectly characterizes Officer Fuston's statement as a definitive statement that the suspect had immediate access to a weapon. This was not the statement made by Officer Fuston in his report. Rather, Officer Fuston stated, "I fear there may be another knife in the bed with the suspect." The statement was based on the totality of the circumstances experienced by Officer Fuston during the radio call. Specifically, there were several large knives in the apartment, and Officer Fuston could not see the suspect's hands when he made first contact. The commission is classifying Officer Fuston's statement that there may be another knife in the bed as dishonest for the sole reason that the Officer Fuston's premonition was incorrect. Just because a premonition turns out to be incorrect does not mean it is a lie. With regard to act number 2, it's unclear what part of the statement the commission believes was dishonest. Officer Fuston was correct in the number of blows he delivered and approximately the half-second time frame between blows. Officer Fuston reasonably believed the 6 blows he delivered were intended to be distractionary blows. Whether or not these blows were categorized as distractionary or impact blows is a question for the use of force expert within internal affairs at the San Diego Police Department. For the sole reason I did not agree with Officer Fuston's categorization of these blows as distractionary blows does not mean he was dishonest when he reported them. With regard to act number 3, as depicted on page 20 of the post-investigative documents, as the suspect's right shoulder hit the ground, Officer Fuston's right hand lost contact with the suspect's upper back. It appears Officer Fuston maintained contact with the suspect's left bicep and right upper back throughout the fall. The first clear loss of contact was when the suspect's lower body and right shoulder had already made contact with the ground. The left bicep and right upper back are both considered part of the upper body. This is not a dishonest statement. The suspect was already on the ground when this right hand came off the suspect's right upper back. Even if Officer Fuston's right hand came off the suspect a split second before the suspect's contact with the ground, it is clear throughout the takedown attempt, Officer Fuston's hands were grasping the suspect's upper body. Officer Fuston thought that he maintained contact with the upper body throughout the takedown, and that's objectively reasonable thought that he had while writing the report. With regard to act number 4, we fully admit Officer Fuston was factually incorrect and misstated the amount of time the suspect was unconscious. This is the reason that Internal Affairs sustained Officer Fuston on failure to accurately document all the facts and circumstances surrounding the force he used during the arrest of the suspect. However, Officer Fuston was not dishonest about his time estimate of how long the suspect was unconscious. If I believed by a preponderance of the evidence that Officer Houston lied, he would have been sustained on dishonesty. Rather, the department clearly believed Officer Houston solely failed to accurately document the facts and circumstances surrounding the force. In every interaction Officer Houston had in this case, the evidence points to an innocent misunderstanding of the medical mechanics of being unconscious. At every point in the radio call, Officer Houston clearly articulates the suspect was unconscious for 2 to 3 seconds. He put that out over the radio, he told that to fire personnel, and finally he put it in his report. At no time does it appear that Officer Houston is attempting to cover up his actions. During his IA interview, he stated that once the suspect was snoring and eyes fluttering, he believed the suspect was conscious. This thought was entirely rational and reasonable in light of Officer Houston's rudimentary knowledge of unconsciousness. In concluding, I was provided all opportunities to sustain Officer Houston on dishonesty and instead only sustained him on failure to accurately report facts related to what has been characterized in the post report as dishonest act number 4. The department did not sustain Officer Houston for failure to accurately report on any other parts of this case. Most importantly, with the lower burden of proof of preponderance of the evidence that internal affairs at the San Diego Police Department uses, the department did not sustain dishonesty as to anything related to this investigation whatsoever. Again, and in summation, ultimately incorrect suspicions or inaccurate depictions should not form the basis for decertifying a peace officer. If this is the standard, then every statement that is ultimately incorrect can form the basis for decertification. We ask that this decertification not move forward. Thank you.
I've prepared a statement if
Yes.
y'all are willing to hear.
Go ahead.
Good morning, distinguished board members. My name is Deputy Dylan Houston, and I'm present today to shed light on the incident in question, as well as provide a perspective on myself as a law enforcement officer that the investigation does not have. I would like to reiterate that at no point in time was I willfully dishonest in anything that I wrote in my report, said in my internal affairs interview, or did on scene. I would also like to reiterate that nothing I wrote in my report was a material fact in charging the suspect with any crime. I was writing a report regarding the events occurred on scene surrounding the use of force against the suspect on scene. I was not the arresting officer, nor did I charge him with any crime that night. I wrote my report from my perspective I had on the scene and from my recollection as I was trained to do in the police academy. The internal affairs investigation you've already been familiarized with was conducted, and I received a 2-day suspension without pay for this incident. Throughout my disciplinary process, I sought out senior officers within my department for mentorship and guidance to make sure that the mistakes I made on the scene did not happen again. I did that all on my own accord without any guidance from anyone else to do that. I accepted my discipline wholeheartedly and returned to duty eager to show that this incident did not define me and who I was as a man or police officer. I made the necessary adjustments and continue to better myself in order to serve the citizens of my community to the highest standard. I continue to work for the San Diego Police Department for approximately another 1.5 years. I was recognized for my high level of police work on multiple occasions and ultimately promoted and selected to a crime suppression team within Central Division in order to specifically address violent crimes within that service area. Throughout my time on the crime suppression team, I received multiple commendations for my efforts to address violent crimes, including catching murderers and several suspects of gang shootings. I made the decision to leave the San Diego Police Department and lateral to the San Diego Sheriff's Department to seek a wider range of opportunities that it has as a larger department within the county. This investigation or my discipline played no factor in me leaving my prior department and moving on to another one. I was not running from any discipline or trying to hide anything from anyone. When I applied to the San Diego Sheriff's Department, I personally went to the Internal Affairs Bureau and San Diego Police Department and retrieved entire copies, including the body-worn camera footage you've seen today, as well as audio and video files to ensure the background investigators of San Diego Sheriff's Department had a complete picture of who I was as a police officer. That also included over 9 commendations that I received after this incident occurred from both my commanding officers and supervisors. I did this to ensure the most transparency and utmost amount of honesty to the department that I was intending to work for next. It has been almost 4 years since this incident has occurred, and I have not received any further discipline for any accord or had any instances of reoccurrence. I made the necessary changes, and I've moved forward and become a better law enforcement officer because of it. I would like to reiterate that I never willfully or intentionally attempted to deceive anyone during this incident through dishonest action or reporting. I did not hide anything from my supervisor who was notified on scene. I did not hide anything from internal affairs or the investigating detectives. I would also like to make a note of the October 20th, I believe, 2022, the incident that happened with the sheriff's department that was alleged excessive force with facial fractures. I was merely there on traffic control. The entire incident had happened prior to me being there, and I did not take, the only thing I did on scene at most was put my hand on her shoulder and try to calm her down because she was extremely high on methamphetamine. As far as the carotid restraint, one thing the investigator left out, a police officer was headbutted and sustained a facial injury prior to me utilizing that carotid restraint. I utilized a carotid restraint I was taught in the United States Marine Corps. It wasn't dangerous or ineffective. It was something that I was trained on to a higher extent than what I was trained on in the police academy. And that's why I reverted back to my training to use it. Ultimately, the suspect in that incident also sustained no injuries from me, nor did he have any repercussions from me using a carotid restraint. Just to give you guys a broader perspective on those incidents, because I understand that after watching the video and just hearing it on paper, you don't have the perspective that I had on scene. Every time I used force in this incident, I was merely trying to protect myself and the other officer on scene. I truly and wholeheartedly believed he made a furtive movement towards his waistband to retrieve a large weapon based off the amount of times I'd been to that apartment and seen him continuously beat that poor woman. Time and time again, which was, excuse me, time and time again, I had seen him beat on her. And every time I was in that apartment, he was aggressive towards me and fellow officers on scene, which was corroborated by a neighbor, which was also left out of the investigation in internal affairs. She stated that every time we came to the door, he got into our face. Regardless of what you saw in the video, he was dangerous towards myself and my partner. And I truly and wholeheartedly believed he was attempting to retrieve a weapon in order to hurt me or my partner. And I had just seen him hurt an elderly female for probably the 4th or 5th time. So I truly believed he was a threat to me. Thank you for your time.
Board members have any questions?
Yes, I do. October 27th, 2019. What role did you play in that excessive force?
So it was a Halloween night. There was a gentleman attempting to gain entry into his vehicle that was extremely inebriated. We initially walked up to him and we're trying to get him an Uber or an ambulance if he needed it to get him home safely, because that was our main mission for the night. He discarded his Halloween costume and ran about a block and a half from us. I chased after him. My partner got back into our patrol vehicle and headed him off. I was able to catch up to him. He gave up. As he was falling to the ground due to his inebriation, I held on to his hands and made sure that he didn't hit his head. And that was the only time I put hands on him that he was not handcuffed. So the only thing I did to him was caretake, ensure he didn't hit his head. I understand that that video does not make me look like I'm not a monster. I've dealt with this for 4 years and I've had to go over these situations time and time again, both in my personal life and within my department. But I can promise you today that I've never intended or meant to hurt anyone by using force. I've only done it, every single time I've done it, it's because I thought I needed to do it in order to protect myself or a victim of a crime. I feel that law enforcement is my calling above everything else. And I truly wholeheartedly love this job. It's given me a lot and I've been able to give back to the community. I've saved people's lives. I've been there for people on their worst days. And I mean, if you want to hear one of those stories, I'd be happy to give it. I understand your time's valuable, but I have one in particular that I would love for you to hear if you have time.
Outside the record. Any other questions by the board? Yes, ma'am.
Were you trained by San Diego Police Department on how to administer distraction blows?
Yes, ma'am.
What is their policy?
So the policy, I wouldn't be able to quote it to you, but at the time I used those distraction blows, I thought I was within policy. I believed I could use a closed fist strike to the upper body. Afterwards, through the internal affairs investigation, I was obviously informed I was out of policy. At the time I used them, I didn't believe that I was doing the wrong thing. If I would have known that, and again, it's my responsibility to know the policy. It's on me. I accepted the responsibility for making that error. But at the time I believed I could use closed fist strikes, but it's actually just open fist, not intended to cause injury, as I believe Mr. Nagel said. But yeah, I hope that answers your question.
Vice Chair, I believe either Mr. Nagel or I can address that question. Okay, so San Diego Department Policy 1.04 use of force distraction techniques. Acts used to divert or redirect a subject's focus away from resistive behavior in order to assist the officer in gaining control of the individual. Distraction techniques may include an open-handed strike and or knee strikes that specifically target the lower body, such as the buttock or thigh area. These are controlled strikes using a lower level of force. These lower level types of strikes are not intended nor likely to cause serious injury. Personal body weapons may be used under these constraints when lesser controlling force has not been effective, or the officer reasonably believes lesser controlled force will not be effective. If a distraction technique provides ineffective, a different distraction technique or force option should be considered. And I think it's worth noting that in the internal affairs report, that the agency found that Officer Houston was using full force closed fist strikes that were not distraction blows.
What type of injuries did the suspect
Stay.
6 fractured ribs.
I believe it was actually 3 from the medical report I've seen, not 6. But I can also tell you about the distraction blows. The reason why I describe them as distraction blows is because my intention behind them. I wasn't trying to hurt him. I wasn't trying to break any of his ribs. I was merely trying to divert his attention away from his waistband where his hand was, so that I could not get hurt and my partner could not get hurt. And my partner was pulling on his left arm with both of his hands and could not get his arm out from underneath his waistband, which I believed meant he was intentionally going for something in his waistband. And I was trained time and time again that weapons come from waistbands. And if someone reaches for their waistbands, I have to act immediately or I'm going to get hurt.
Questions?
December 14th, the chokehold was out of policy. That's correct?
Yes, sir. So I applied a carotid, sir, not a chokehold. I didn't crush his windpipe at all. So I did not choke him. The reason why I was out of policy is purely because I used a carotid restraint that I was taught in the Marine Corps and not at San Diego Police Department. I can reiterate that he didn't suffer any injury whatsoever from it.
Crawford.
On hindsight of everything, you were able to counteract everything that was said. In that given situation, would you have used the same level of force? Or not force, because it's alleged. Would you use the same tactics that you used? My question.
I think at the end of the day, at the time, you're watching that video, I had 8 months on as a law enforcement officer. I didn't even have a year off training. So to say that I wouldn't approach a situation different after now 5 years and a wealth of experience would be wrong. Because I think as law enforcement officers, we learn from every single call we go to. I've learned these internal affairs investigations and even coming to this board have taught me an immense amount about law enforcement. I've learned every day I've been on the job, and that's why it's never happened again. I made a mistake. I owned up to it. Never once did I say, oh, this is not my fault. I took it directly on. I made a mistake. I made the necessary adjustments and I moved forward from it. Obviously, I can't go back in time and undo certain things or not other things, but I know where I am today as a law enforcement officer. I have a wealth more of knowledge to be able to handle all sorts of situations, and that's why you've never seen it happen again. And that's both working with the agency that wrote these investigations and the agency now that I work for that's larger than that previous agency.
Anybody from the public that would like to comment on the presentations? Please state your name.
My name is Diaz. Several levels. And I wish somebody on the board would have asked the question about it. His hitting to the suspect, did he actually put that in his report? Other thing is that, from what I saw, the suspect was turned over first. He was asleep. He was drunk. He was asleep. He was turned over first, and then he was turned back. There was an opportunity to see if there was a weapon there or if he had something in his hand, because on this side, he was turned over. He was asleep, and then he was turned back over. So the knife part about thinking it was a knife in order to hit, I couldn't see life being threatened when you already turned him over and he was dead asleep. And if there was other knives in that place, he was handcuffed going by the kitchen. And so the devastation of police officers to be able to lie affects families in such a way. It's a slow burn. And so I just think it's important that, and the fact that he said that he's learning, I don't think police officers should learn on the job, because the ability to take life, they have the biggest job, because in a split second, they have the ability to take a life. And as families impacted by this, our loved ones never come back. And so I just wanted to say that. Thank you.
Thank you. Anyone else from the public would like to speak? Okay.
Vice Chair, can I make one quick comment before? Sure. So Mr. Fields attempted to downplay how this turned out in the internal affairs investigation. And there's a quote that I just wanted to read from that investigation that I think really kind of displays how serious this was as far as dishonesty and accuracy. So it said, Officer Houston's lack of a feasible, safe plan to take Carrera to the ground after he performed an unauthorized leg sweep takedown on a handcuffed prisoner resulted in Carrera being knocked unconscious. Officer Houston told medics and fire personnel Carrera was unconscious for 2 to 3 seconds. In reality, Carrera was unconscious for approximately 2 minutes and 58 seconds. Officer Houston had a duty to care for the well-being of Carrera, who was in his custody, but instead provided medical personnel inaccurate information as to how long Carrera was unconscious. Officer Houston admitted to being wrong in his time assessment of Carrera being unconscious, thus providing a wrong injury assessment to medical personnel for an injury he had caused, which is important because he has a duty to convey appropriate information to medical personnel so that they can treat this individual. But we feel that he was dishonest in that causing harm to the suspect. One quick thing too that I wanted to mention, and I think that it was touched on briefly, was that you received some statements that are purported to be from members of the public that were submitted by Officer Houston. It was mentioned to you that this is irrelevant and outside of the record, and I just wanted to touch on it briefly. So if this was a normal hearing, we would have an opportunity, both sides, to present evidence and cross-examine witnesses. If there was character evidence that somebody tried to submit, which is questionable in a hearing, but if there was, I'd have an opportunity to ask these individuals, did you actually make this statement? I'd have an opportunity to ask, how well do you know Officer Houston? I'd have an opportunity to ask them if they knew certain instances of bad conduct by Officer Houston and if they changed their opinion about him. And consequently, I'd have an opportunity to submit instances of bad conduct. That's not happening here today. That's why I just want to highlight that those statements are irrelevant to the record and they're not relevant to the inquiry here today. So.
If necessary.
May I respond since I was referenced in that comment?
Yes, go ahead.
Thank you. Briefly, just very briefly, just to direct everyone to, why we're here. While I understand we're here, the context of why we're here is based on an allegation of force and an instance and use of force. The specific allegations that you're here to determine today are whether or not Officer Houston was dishonest, not whether he used excessive force or not, because that is jurisdictionally, that is the basis for what you have before you. Again, as to the issue of the unconscious, Officer Houston admitted he made a mistake. His rudimentary understanding at the moment of time was the unconscious was when, in essence, he wasn't he wasn't responding at all. And very clearly in that video, within 2 to 3 seconds, you can hear the suspects certainly audibly snoring. I think everybody would admit that. It was a mistake, and he admitted it was a mistake. And I think what really what is extraordinarily important that you recognize here is that this was investigated by one of the largest agencies, law enforcement agencies in the state, the San Diego Police Department. Extraordinarily large agency. Again, one of the largest law enforcement agencies in the state, very good reputation. And it determined that Officer Houston was not dishonest in anything that he did in relation to these allegations in this particular incident. Like as Officer Houston has told you, a while afterward, a year or so afterward, he applied to lateral to the San Diego Sheriff's Department, an even larger agency, law enforcement agency in the state, does extraordinarily thorough backgrounds. They reviewed this incident. Now, obviously, if they thought that Officer Houston had been dishonest in his in this incident and the reporting and his testimony regarding this incident, they wouldn't have touched him with a 10-foot pole, and they hired him as well. So in essence, you have two of the largest law enforcement agencies in the state having reviewed this incident with a fine-tooth comb and determined that there was no dishonesty here. I understand that obviously is not not the findings that we're here on today, but I ask you to consider that very heavily as you make this decision, because again, he made some mistakes. There's no question he made some mistakes here. He made some mistakes in his use of force, and he made some mistakes in the way that he characterized what he had done. But mistakes and dishonesty are two different things. And with that, I will conclude. Thank you.
Okay. We will now we'll adjourn and go into closed session, and we'll do that in another room. So thank you.
Thank you all for your time.
A vote on the board's recommendation to the commission in the matter of case post 2300809 Dylan Houston who at the time of the events at issue was employed by the San Diego Police Department. What comments do the board members have?
Oh.
Yes, Ms. Pena.
I'd like to make a motion,
Okay,
motion to recommend decertification.
okay. Is there a second?
Second.
Second by Mr. Johnson. Vote. Oh, excuse me. Oh, is there any public comment?
Okay. Board Member Bushin. Board Member Clavo.
Aye.
Board Member Crawford. Board Member Doyle.
No.
Board Member Dudley. Board Member Glacier.
Aye.
Board Member Johnson. Board Member Lara. Board Member Pena.
Aye.
Vote.
And we have 4 ayes, 2 abstentions, and a no.
Motion passes. No. We're going to break for lunch.
Why don't we do 45 minutes to bring us back?
45 minutes, 1:30.
Yeah.
Okay, we're adjourned until 1:30.
Thank you.
Thank you.
If not non-existent.
Back on live.
Man, yeah, my dad did.
There we are. Good afternoon. We're back on the record. I wanted to call on Chandler Knapp to clarify the vote count from our previous case.
Thank you, Vice Chair. I want to clarify for the matter of Dylan Fooston, post 2300809. I'm going to reread the votes into the record and correct one thing that was previously stated. Board Member Clavo, aye. Board Member Crawford, abstain. Board Member Doyle, nay. Board Member Glacier, aye. Board Member Johnson, aye. Charles Lara, recusal, previously stated as an abstention. So that's the correct correction for the record. Board Member Pena was an aye, and the motion still passes.
Thank you. At this time, I will call upon law enforcement consultant Kevin Sherburne, Professional Conduct Central Bureau, and Brian Henley, Legal Affairs Bureau, to provide a report on case post 2300204, David Wesley Hubbert, who at the time of the events in issue was employed by the Kern County District, is employed now by the Kern County District Attorney's Office, then by the Kern County Sheriff's Office. Gentlemen.
Thank you, Vice Chair Doyle. Thank you, board members, for your time today. My name is Kevin Sherburne. I am a law enforcement consultant, and I served as the investigator on this case. With me to my right is Brian Henley. He is legal counsel for Post. I serve in the Professional Conduct Central Bureau, so Central Bureau handles Kern County. This case today is regarding David Wesley Hubbert. The case number is post 2300204. He formerly is of the Kern County Sheriff's Office, and he currently is assigned with the Kern County District Attorney's Office. He is subject to an immediate temporary suspension of all of his certificates. That suspension became effective March 9, 2023, and remains in place today. The ITS, as it's known, was based upon Mr. Hubbert's termination for serious misconduct and/or separation pending an internal investigation. The summary of this case is that the division found clear and convincing evidence that Mr. Hubbert abused his power and was dishonest. For the purposes of the division's findings, clear and convincing evidence means there is sufficient evidence to establish that there is a high probability that the charge is true, and the evidence need not establish a fact beyond a reasonable doubt. What I'd like to do now is go through a little bit of background on the case. Mr. Hubbard began working at the Kern County Sheriff's Office on October 6, 2007. He promoted to sergeant in 2015 and to lieutenant in 2020. Mr. Hubbard started working for the Kern County District Attorney's Office in August 2021. Over the years, Post issued 4 certificates to Mr. Hubbard: a basic certificate in 2009, intermediate in 2011, advanced in 2015, and a supervisory certificate in 2018. The facts and a timeline are set forth in the investigative summary and findings, known as an ISF, which are on pages 9 through 13. For ease of reference, I've summarized the timeline of significant events in a slide. IT department, would you please display the slide? If I understand that board members have already received a copy of this slide, and earlier this morning, Bryant Henley, counsel for Post, emailed Mr. Hubbard's counsel so that they had a copy of this to follow along in case this did not display on their screen. So they have a copy of that as well. In my presentation, I will use the terms suspect 1 and victim 1 as they are defined in the ISF. Please refer to the ISF for more detailed information about the factual background of what I'm providing here in person today. In short, here is a brief factual background of the case. Mr. Hubbard held various assignments as lieutenant during the times relevant to my investigation. His assignments, based on Kern County Sheriff's Office practices and policies, as well as for legal reasons, dictated what access and role he had with respect to criminal investigations and with respect to internal affairs investigations. Criminal investigations take precedence over internal affairs investigations. IA investigations, as they're known, are put on the back burner during ongoing criminal investigations. This practice is known as tolling. The investigation is tolled during the criminal investigation. At Kern County Sheriff's Office, the Professional Standards Unit, I may refer to that as PSU, conducted criminal investigations of peace officers. As lieutenant of the Internal Affairs section, Mr. Hubbard interfered with the criminal investigation of suspect 1, who was alleged to have sexually battered victim 1. Suspect 1 was another deputy at Kern County Sheriff's Office. Victim 1 was a civilian employee at the same office. The alleged sexual battery occurred while Mr. Hubbard was the lieutenant of the detective section, where both suspect 1 and victim 1 reported to him. After Mr. Hubbard transferred to be lieutenant of the Professional Standards Unit, which handled criminal investigations, Mr. Hubbard interfered with the internal affairs investigation of suspect 1, as I will detail later. Throughout the months from the initiation of the criminal investigation of suspect 1, Mr. Hubbard took personal actions that conflicted with his professional obligations, including accompanying or representing victim 1 with the Kern County District Attorney's Office in May 2021. The culmination of those personal actions occurred over a weekend in late November 2021, when Mr. Hubbard had sexual intercourse twice over 2 days in his office with victim 1, who was a direct report to him, and while he was acting as the watch lieutenant, which is the highest ranking law enforcement officer on duty at the time. And Mr. Hubbard proactively obtained information from the internal affairs investigation of suspect 1 and shared that information with victim 1. Then he destroyed evidence relevant to that internal affairs investigation and to a potential internal affairs investigation into his own conduct. In my investigation, the division found clear and convincing evidence that Mr. Hubbard engaged in serious misconduct. Again, abuse of power and dishonesty. Under abuse of power, Mr. Hubbard abused his power when he interfered with the IA investigation of suspect 1. He provided input on the investigative strategy and interview questions to suspect 1, while simultaneously serving as the personal representative to victim 1, having a sexual relationship with her and sharing information he learned during the IA investigation with her. Mr. Hubbard abused his power when he had on-duty sexual intercourse twice with victim 1 in his office, even taking into account that both Mr. Hubbard and victim 1 stated that the sex was consensual. Victim 1 was a direct subordinate reporting to him. At the time he had sex, Mr. Hubbard was serving as the watch lieutenant. 3 days after Mr. Hubbard had sex with victim 1, Mr. Hubbard proactively sought confidential information about what suspect 1 had said during his internal affairs investigation interview. The IA investigator viewed Mr. Hubbert as a mentor and a leader. Mr. Hubbert did not first disclose to the IA investigator that he had just had sex with victim 1 when he sought the information from the IA investigator. The IA investigator would not have revealed information to Mr. Hubbert had he known about Mr. Hubbert's sexual relationship with the victim. The information that Mr. Hubbert learned during his discussion with the IA investigator was significant because Mr. Hubbert learned for the first time that suspect 1's defense was that Mr. Hubbert and victim 1 had an affair. Thus, Mr. Hubbert knew that his alleged intimate relationship with victim 1 was now a key aspect of the internal affairs investigation of suspect 1. After obtaining this confidential information, Mr. Hubbert abused his power by sharing it with victim 1 by telling her what suspect 1 had said, including that victim 1 consented to the sexual battery and that victim 1 and Mr. Hubbert had an affair. Mr. Hubbert knew it was wrong to share the information, but he shared it anyway. After learning what suspect 1 had said about Mr. Hubbert and victim 1, Mr. Hubbert abused his power by deleting work phone text messages and phone log records of communications between himself and victim 1. He destroyed the evidence knowing that the information was relevant to the IA investigation of suspect 1 and to a second potential IA investigation into his own conduct. The division made second findings with respect to dishonesty. Mr. Hubbert failed to disclose material information related to criminal and internal affairs investigations by not revealing the conflict between his personal interests and his professional obligations. His destruction of relevant phone calls and text messages destroyed evidence intentionally and purposefully to conceal his own misconduct. The division recommends revocation of Mr. Hubbert's certificates based upon his serious misconduct. This is not solely a case of an extramarital affair. This is not a one-time instance of sexual misconduct or indiscretion. Even while I interviewed him, Mr. Hubbert continued to downplay the negative impact that his decisions had on the integrity of 2 ongoing investigations, the stature of the sheriff's office, and the well-being of the victim. This case goes to the very heart of what it means to be a peace officer in the state of California. Mr. Hubbert's actions cut against the core values of being a peace officer, and they affected the entire law enforcement community and the public. Mr. Hubbert abused his power and was dishonest over a period of several months. He had a conflict between his personal interests and his professional obligations on multiple levels. He was wearing 2 hats at the same time. The multiple levels include the victim. He took advantage of the victim personally and professionally. The victim was particularly vulnerable over the weekend he had sex with her because the IA interview of her alleged attacker was imminent, and Mr. Hubbert knew that she was anxious about the interview. His actions affected his fellow law enforcement officers within his own department. He betrayed the trust of people who saw him as a leader and a mentor. As a superior officer within the Kern County Sheriff's Office, Mr. Hubbert abused his position of authority and his status as a mentor to gain access to confidential information that he shared with a party to the case. He also misled his own command staff. Mr. Hubbert's actions affected the integrity of investigations in Kern County. He compromised the internal affairs investigations of other peace officers and his own internal affairs investigation. He compromised the integrity of other sex crimes investigations conducted by the Kern County Sheriff's Office. He played 2 incompatible roles at the same time, as a Kern County Sheriff's Office investigative team member on one hand, and as victim 1's personal representative on the other hand. At the Kern County District Attorney's Office, Mr. Hubbert's role allows him continued access to criminal investigations like the one in this case. Mr. Hubbert's actions affected the community at large. Mr. Hubbert breached the trust of the community, which expects that investigations will occur without favoritism or bias or interference and without destruction of evidence. Mr. Hubbert was dishonest. He destroyed evidence after learning it may be needed in a case against another officer and what he surely knew would be a case against him. Mr. Hubbert sought out and then improperly shared confidential information. Given his rank, training, and experience, his actions are especially egregious and warrant revocation. At this point, I'm happy to answer any questions that the board members may have.
Board member questions?
You stated that the, Mr. Hubbard downplayed, facts as pertained to your investigation. How would you sort of operationalize? What was that you saw to your eyes was the downplaying?
He made statements and to the effect that it was minimized, that the impact was not as great. Do we want to play the audio? Yeah. At this point, I would let you listen to the Mr. Hubbard's own words. Can we play an audio clip, please? This is attachment Z. Excuse me. This is attachment Z to the investigative summary and findings.
Give a little background of what this part is about, or shall I?
Yeah, please go ahead.
And members of the board, just to prepare you for this audio, this is a colloquy between the internal affairs investigators and Mr. Hubbard, where they're asking him about the sexual intercourse he had with victim one while serving as watch lieutenant 2 days in a row. Well, watch lieutenant, that's what this question relates to. And we'd ask you to listen to his response.
Would a sexual encounter while on duty take you away from your duties?
I mean, the obvious answer is yes. As terrible as it sounds, I had my radio on. I had my phones on. I was available as needed. I was covering as a watch lieutenant. So I would have been in my office anyways. It wasn't a normal day for me to work. I'd already worked all of my time for that week and was working all of my time for the next week. So I was volunteering to be there. I feel I was available to respond if anything required my attention. However, just purely by the nature of what was occurring, that is correct.
Okay. So do you feel you were still able to effectively manage KCSO operations as the ranking member at that time?
I feel like I was able to respond to any situation which required my attention, however, was not actively monitoring KCSO operations for the county at that time.
Do you feel this is...
In addition to the clip that was just played, during my interview of Mr. Hubbard, which is at attachment G to the ISF, and this goes to post-regulation 1213 and the factors of mitigation or aggravation with respect to his conduct. He did not appear to appreciate the harmful nature of his misconduct. He stated that it was splitting hairs to go after him for sharing information, that nothing affected his ability to perform as a peace officer. As her personal representative, he said he would learn it anyway. I would contend that that is factually not true. Once the relationship became known, he would not have been able to serve as her personal representative. I would also point the board members to attachment E, which is the notice of disciplinary action termination. It's a letter to Mr. Hubbard from the Kern County Sheriff's Office, from the sheriff himself. At the Skelly hearing, the conclusion on page 5 of that attachment, you accepted responsibility for your actions, however, minimize the gravity of obtaining and releasing confidential information, as well as the consequences your actions could have on the sheriff's office. Due to your misconduct, you have exposed the sheriff's office to unnecessary liability for multiple active and former members of the sheriff's office. You violated the right of a fellow employee to confidentiality in his internal affairs investigation. Additionally, you isolated a potential sexual assault victim by moving her under your control and assuming supervision of her. It continues from there. These are examples of how I would answer your question, Board Member Lara, as to what was it that I concluded, what supported my conclusion that he downplayed his role and his activities.
The interview that we were all sent and listened to, was there I didn't have a picture. It was just the audio. Did you videotape it?
There may have been two audio recordings of interviews. The one was the clip that we just played, which was Mr. Hubbard's internal affairs interview. The second interview that was conducted, I conducted with a fellow law enforcement consultant, and that was not videotaped. The IA interview, I don't think was also videotaped either. Some departments videotape and audio tape, some only audio tape.
Yeah, I just wanted to comment that it would have been helpful to have a visual tape to not only hear the audio, but to be able to look at body language, etc., while we're listening to it. Just
Any other questions? Post has received written comments from the public concerning Mr. Hubbert. The division is making them available to you with the following caveats. At this stage of the proceedings, the only issue for the board is whether or not the division's investigative summary and findings provide clear and convincing evidence of serious misconduct. The division's position is that character statements of this kind are not relevant to this inquiry and might be provided, if at all, only during a later evidentiary hearing. In excessive caution, however, staff will provide the letters to you as public comment, keeping in mind that the board's ultimate task is to determine the sufficiency of the division's investigative summary findings. At this time, does the subject officer or counsel wish to make a public comment? Please state your name and organization if you wish.
Hi, my name is Casey Castillo. I am the representative counsel for David Hubbert, and I would like to be heard.
Please proceed.
Thank you. Thank you for the opportunity to address the sufficiency of the findings. In the instance of David Hubbert, they are insufficient for commission review on revocation. Considering the factors outlined in section 1213 of the Code of Regulations as it pertains to abuse of power, there is no evidence that his relationship with Ms. Doe was inherently coercive. Indeed, there's no evidence from the investigation that was coercive at all. The two of them were long-term friends and co-workers, and as stated by the investigator, their relationship was consensual. And while the order and findings reference abuse of power and gathering confidential information for the purpose of sharing it with Ms. Doe, there is no evidence that the information was shared for that purpose, nor believed to have been confidential at that time. Indeed, the information sharing was in response to questions from her on the process, and not with any desire or intent to tamper with the outcome of an ongoing investigation into someone else. And as this investigation made clear, both Ms. Doe and he faced their mistakes head on. Further, Hubbert took the additional step of contacting his superior and self-reporting when it became clear he had overstepped. As it pertains to dishonesty in the method of evidence tampering as it relates to the deletion of texts and call logs, for acts to be characterized as such, there must be an intent to deceive, and it must be willful, knowing it would cause a certain result. Deletion of his contacts with Ms. Doe was not done to hide or impede any investigation or conceal evidence, but rather to avoid an issue at home. Hubbert did not fail to disclose. In fact, he self-reported to his supervisors and his spouse the relationship. Notably, the investigation undertaken by his original investigating agency did not, even with the low burden of preponderance of the evidence, sustain or even allege dishonesty of any type in any form. As it pertains to the mitigating factors that were addressed by the investigator, Hubbert remains employed as a peace officer, albeit as a result of these proceedings, currently in a non-sworn position. He remains employed because, despite this episode in his career, his history in law enforcement has proven that he is a person of integrity and someone whose true character showed when faced with his mistakes. After the investigation, Hubbert resigned his position, and after a full, transparent, and customary background investigation, he was hired at the Kern County District Attorney's Office as a district attorney investigator. He is, again, currently employed there. It is important to note that this was essentially a voluntary lateral demotion, given the same county employer but different division. Had this transfer not occurred, Hubbard would have proceeded to hearing before the Civil Service Commission in relation to the penalty imposed. As it pertains to his prior conduct, discipline, and service record, and any other prior instances of misconduct, before you, you have an example of an individual with a record of prior conduct that is exemplary, with no prior discipline, and with evaluation ratings consistently above standard. The actions that bring David Hubbard before you are isolated, personal in nature, and span the course of a short period in 2021, in contrast to an admirable career of over 16 years. The events before the board occurred over the few months in 2021, and Hubbard did in fact take a voluntary demotion and reassignment, and he has been working since without incident. Other mitigating factors that I believe are important are that he acknowledged and accepted discipline for his mistakes as was appropriate. And while he was remorseful, much of his error in judgment was human and born out of extreme personal stress in the immediate prior months as the result of his own participation in an officer-involved shooting involving the death of his friend and coworker. Anyone who has experienced such a significant event and personal loss can attest to the impact to sound mind and judgment that occurs, but is also unlikely to reoccur absent such stressors. This event may have been catalytic, and there is no doubt that the behavior that immediately followed was completely out of character for this peace officer. And while his judgment momentarily lapsed, he self-reported to his supervisors. Hubbard unwaveringly expressed remorse and accepted responsibility. He was forthright in his dealings with his agency during his investigation, as well as the district attorney's office, who subsequently hired him after that full background investigation. And then later, the post-investigator. The honesty and candor in this investigation is evidence of rehabilitation and mitigation as is moving forward with his current employer. He's additionally sought counseling with his wife, and they are in a good place. The issues before you will never reoccur, and even a cursory review of his personal life and law enforcement career supports such a conclusion. In summary, a fair and objective review of the findings do not support furtherance of the revocation process for David Hubbard. His continued service as a district attorney investigator is not a threat to health, safety, or welfare of the public, and the findings do not properly impart a holistic review of his candor, his long-term record of public service, and lack of any disciplinary history in almost 2 decades of service to the community. Thank you.
Any questions? Hearing none. Would like to address the board at this time? No.
Mr. Vice Chair.
I'm sorry.
If we could speak to Ms. Castillo's comments with your permission.
I'd like to start. First, counsel for Mr. Hubbard mentioned post-regulation 1213. I will speak briefly to a couple of points that counsel mentioned, but then I will defer to Mr. Henley, post-legal counsel, for further information about 1213. I believe that Ms. Castillo misstated the division's job and the definition of abuse of power. The abuse of power, she cited that there's no evidence of it being inherently coercive. That is not part of the definition that the division is looking at. Whether the information, whether the acts occurred is what is at issue here today, not post-regulation 1213, which is what level of discipline the commission may impose. Ms. Castillo also said that he did not have the intent to share information. And that issue is irrelevant for my inquiry during my investigation. He also had recognized that he could not share it. He told victim one that he could not share the information because it was confidential. That level of intent pushes it over the line in my eyes. Ms. Castillo also said that he self-disclosed. This is a little bit misleading because he did disclose it to his wife, perhaps, according to him, but there was a time lapse of him disclosing this to his supervisor, and he waited until after victim one had reported the misconduct. And during that time period, Kern County Sheriff's Office was flying blind with respect to suspect one's internal affairs investigation, and they were trying to wrap up that investigation, and they didn't know about the evidence that he had deleted, and that evidence was not only relevant, but it was material to his own internal affairs investigation. But with that, I'll just ask Mr. Henley about 1213.
Thank you, and members of the board. I think law enforcement consultant Sherburne's really covered this well. The point I wanted to emphasize to you today is Ms. Castillo, on behalf of Mr. Hubbard, has spoken a lot about Regulation 1213. And as Mr. Sherburne has explained, it's important to level set that the purpose of today's proceedings aren't so much to focus on the 1213 factors. Those are actually factors that are directed to the commission. By the definition in the regulation, it's the commission that is to weigh those factors in rendering a decision. For purposes of today, the question before this board is there sufficient findings from Mr. Sherburne's investigative summary and findings? Are there sufficient findings to show by clear and convincing evidence, one, that former Lieutenant Hubbard abused his power with the conduct we've described to you today? And two, did former Lieutenant Hubbard engage in dishonesty in deleting text messages and phone call records, as well as omitting important details that affected both an internal affairs investigation about another officer and a likely internal affairs investigation of Mr. Hubbard himself? Those are the questions before this board. If the board determines that Mr. Sherburne's evidence is clear and convincing, the appropriate action we recommend, the division recommends, is revocation, and that serious misconduct in fact occurred, and to recommend that the commission consider revocation as the appropriate action. And with that, we remain available for questions.
Questions? No? Okay. At this time, the meeting will be adjourned, so the board can go on closed session.
Not yet.
Oh, sorry. Okay, we will now reconvene to regular session to take a vote on the board's recommendation to the commission in the matter of case of post 2300204 David Wesley Hubbard, who at the time of events at issue was employed with the Kern County Sheriff's Office, now with the Kern County District Attorney's Office. Is there a motion by the board, take a recommendation to the commission? Yes, Ms. Crawford.
I'd like to make the motion to decertify.
Certify, is there a second? Yes. Mr. Glasser? Take the roll, Chandler.
Board Member Buchan. Board Member Clavo.
Aye.
Board Member Crawford.
Aye.
Board Member Doyle.
Yes.
Board Member Dudley. Board Member Glacier. Board Member Johnson.
Aye.
Board Member Lara.
Aye.
And Board Member Pena.
Aye.
Board Member Crawford. Board Member Doyle. Yes. Board Member Dudley. Board Member Glacier. Are you done Board yet?
Member Johnson.
That's 7 yeses.
Board Member
Okay, motion passes.
Board Member Pena. Aye. Board Member Crawford. Board Member Doyle. Yes. Board Member Dudley. Board Member Glacier.
Are you done
Board
yet?
Member Johnson.
That's 7 yeses.
Board Member. Okay, motion passes. Board Member Pena. Aye. Board Member Crawford. Board Member Doyle. Yes.
Pause for a minute while we figure out the IT issues.
Board Member Glacier.
That's funny too.
Are you done? Board Member Johnson.
That's 7 yeses.
Board Member. Okay, motion passes. Board Member Pena.
That's 7 yeses.
Be on hold for just a second until we figure out the IT issues. Bear with us.
Thank you.
Oh. What, can we take a comment?
Understand there is someone has called in that would like to make a comment on the previous case, Hubbard case. Go ahead.
Hi there, can you hear me?
Yes.
Hi there, this is Daniel Sanchez, 18-year veteran with the Sheriff's Office.
Called in that would like to make a comment on the previous case, Hubbard case. Go ahead.
Hello, so I just want to thank you guys for your service. Thank you for the effort that you put into these types of investigations, Mr. This is Daniel Sanchez. Mr. Sherburne, again, thank you for the investigation that you conducted into the David Hubbard investigation. I believe that it was necessary to send a message to the Sheriff's Office that this behavior will not be that will not be tolerated by you guys. But unfortunately, there is more to this story than what you discovered. There is an entire background of information that led to this incident, and I believe that there is possibly more officers that are potential SB2 issues. I don't believe that the Sheriff's Office was caught without having knowledge of Mr. Hubbard's behavior. Again, I think that this is possibly something that maybe you and your commission may consider looking into. I'm available for contact if you would ever like to contact me so that I can share additional information. I want to reiterate that this was a good decision. Again, thank you. And I also want to add that I am off duty just in case somebody decides to trigger an internal affairs investigation against me. Again, there are very few officers out there that will speak out. I think there are officers that can provide inside information into the behavior of these organizations. I don't believe that some of these organizations are capable of investigating themselves, especially when it involves investigations like this type of investigations. Again, there was a plot to get Mr. Hubbard out of the Sheriff's Office to save his career. And there is a lot more people involved into the manner in which this investigation was conducted and the outcome of it. And thank you again.
Thank you for your comments. Okay, the next case is Ivan Sarabia Medina, post 2322012 and post ID C12-A96. This time I will call upon law enforcement consultant Robert Bringoff, Professional Conduct LA Bureau, and Brian Henley, Attorney Legal Affairs Bureau, to provide a report on this case.
Thank you, Vice Chair. Good afternoon, everybody. My name is Robert Bringoff, and I'm one of the law enforcement consultants assigned to the Los Angeles County Professional Conduct Bureau. We operate in the Peace Officer Standards Accountability Division, and you've all met Brian Henley sitting next to me, an attorney with our Legal Affairs Bureau. I'm here to present case 23-22012 involving Los Angeles Sheriff Department Sergeant Ivan Sarabia Medina. I may refer to him as Sergeant Sarabia during this. Sergeant Sarabia started his law enforcement career as a deputy sheriff with the Los Angeles County Sheriff's Department in 2007. He was promoted to the rank of sergeant in 2016. He has had no other law enforcement appointments in the state of California. In August of 2022, a retired Los Angeles Sheriff Sergeant contacted the Internal Affairs Bureau after watching several of Sergeant Sarabia's videos on the social media platform TikTok. Internal Affairs investigators watched the videos and believed Sergeant Sarabia was in violation of several LASD policies, as it appeared Sergeant Sarabia was filming TikTok videos for his personal TikTok account while he was on duty as a sergeant. An internal affairs investigation into Sergeant Sarabia's on-duty filming of TikTok videos led to 2 separate internal affairs interrogations in which Sergeant Sarabia was asked in no equivocal terms whether he was filming the TikTok videos on duty. Sergeant Sarabia stated he had never filmed any of his TikTok videos while on duty. The division reviewed several videos from Sergeant Sarabia's personal TikTok account. We reviewed the internal affairs investigation interrogation transcripts. And upon review of the videos and transcripts, it was clear that Sergeant Sarabia was repeatedly dishonest with internal affairs investigators. That dishonesty was clearly intended to cover up his misconduct, and the motivation to cover up that misconduct was plainly evident. At several points in the TikTok videos, Sergeant Sarabia's watch was visible while he was filming. In those instances, his watch showed the time the video was recorded had fallen within the hours of his scheduled work shift, which was 2100 to 0500 or 9 p.m. to 5 a.m. Same time frame. In another video, Sergeant Sarabia films himself in a police car in full LASD uniform and states he has a couple hours left in his shift. A further aggravating factor in this case is Sergeant Sarabia's status as a supervisor, one who would routinely act as the watch commander for the Walnut Station in the absence of a lieutenant. Sergeant Sarabia's lack of integrity calls directly into question the accuracy and objectivity of his written reports, his testimony, and his workplace evaluations of subordinates. Sergeant Sarabia was terminated from the Los Angeles County Sheriff's Department for dishonesty related to this case. The facts I've just relayed support the division's findings that Ivan Sarabia Medina was involved in serious misconduct, specifically dishonesty relating to the investigation of misconduct of a peace officer. For purposes of the division's analysis, as you've heard, clear and convincing evidence means evidence of a charge is clear and convincing so long as there's a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. I'm happy to answer any questions.
Board members?
No, thank you, Vice Chair. Not at this time.
This time, does the subject officer or counsel wish to make a comment? Is there anyone in the public who would like to make a comment on this case? Hello?
One question, I'm
Go ahead.
sorry. Is there any indication that at any point along the way, the sergeant was given any indication that he shouldn't be posting images on social media that were taped during his shift?
Yeah, there's a policy against it. There was a few policies. Those are mentioned in the back of that record that I provided. It was pretty well understood. And in fact, there was one statement I'm happy to read that was in that ISF that I think might shed a little bit of light. Let me just pull it up. It's towards the end of page 23 of the investigative summary and recommendation that I drafted. He says to the internal affairs investigator, Sergeant Sarabia says, I always made it my goal to, every time I record something, to make sure that I'm, before my start time or after my end time, I've always made it a goal to, make sure that it's off duty, because it's pretty obvious that if you're on duty, you're doing any social media, that might get you in trouble. And that was a direct quote from him taken out of the transcript. So it seemed relatively clear that that was not.
Hello? We'll be right with you. Mr. Laura?
Just real quick, I also, you prompted a memory. So some of the videos, they show him covering up what is referred to by the agency as their intellectual property.
Right.
Covering up of the badges, the star, the rank insignia. So to my mind, that would show some of the requisite knowledge that, hey, this is probably not per policy.
That's correct. At some point in time, he was approached by a supervisor. I don't recall the rank of that supervisor. I believe somebody at a command level who had indicated, look, you cannot be showing the intellectual property. That's one of the issues that we're having. And so to remediate that, he put the stickers, I believe they're called, on the TikTok app. He put these digital stickers over the intellectual property. That being said, the assertion was that none of it was happening on duty. And so the places in which we found repeated acts of dishonesty as they relate to the investigation into misconduct was the repeated assertions that he did not do any of this while on duty. And that was just clearly not the case. Ma'am.
Yeah.
What was the time frame between when he started posting on TikTok and when he was talked to by his superiors about not doing that?
Yeah, I'm not sure. That's a great question. I'm not sure when they all started. The record that I was provided was it contained several TikTok videos. There may have been more that existed at one point in time when I started looking at this investigation and when the division started reviewing this investigation. His personal TikTok that these videos had previously existed on had been taken down. He does have another personal TikTok account online now, but they do not include these videos. They include separate types of videos. So I wasn't able to necessarily identify how long he'd been doing it until he'd been spoken to. Yeah, and then how long he continued to do it afterward. The issue at hand in this case, just showing the dishonesty, was not necessarily that he hadn't had an opportunity to take them down or that he was trying to comply by covering up the intellectual property. The main issue that the division is addressing in the dishonesty is the fact that he's saying he didn't do any of this while he was on duty. And that's, we've proven to a clear and convincing standard that that's not the case. To include times in which he even tells people on the TikTok video, I'm on duty, right? I have a couple hours left of my shift, or he explains what time it is, his watch showing that the time frame it was recorded fell within his work hours. And another assertion that he said he never came to work on one of his days off to film the TikTok video. So if he was there, he had to have been on a work day, and if it fell within the hours of his work shift, he had to be on duty. So that's the issue, the dishonesty that we're addressing, and that was clearly provable.
What if all of the TikTok videos were done in his patrol car, etc., but not on work time?
Well, if they were done that way, he wouldn't be lying, but they weren't. So had he done them in his patrol car, here's the thing, if he's in his patrol car and he's wearing full uniform and he's in public, the assumption is that he's on duty when he's doing these things. The fact of the matter is, in his internal affairs investigation, he was asked in no unspecific terms if he did these things when he was on duty. And he said he did not. He never did. It's not something he did. He never filmed any of his videos on duty. And so there was nothing to support that other than his statement that he didn't do it on duty. He never provided any evidence that he did these things off duty. There's nothing there. We're seeing him in a patrol car with his body-worn camera on, with his watch saying that it's within his work hours, in full uniform, with his badge, in a police car. At times, in some of the videos, you hear a radio transmission that the internal affairs investigators were able to track down and determine happened during his work hours. I mean, had he done those things, it may not have been a violation necessarily of the sheriff's department's policy, but that's not what the record is speaking to. Right. Specifically, and I don't want to presume that I understand the nuances of their policy in this case. Really, what we're dealing with is an allegation of dishonesty that was presented by the agency, that he lied in the internal affairs investigations, and that was proven to a clear and convincing standard by the division.
Any other questions? One moment. Ready? We understand that there is a representative of Mr. Medina on the call or on video. If there is, please identify yourself and go ahead.
Good morning. Good afternoon, everybody. My name is Saku Ether. I am the attorney that works with POPA, the Sheriff's Department Union, and I am currently representing former Sergeant Ivan Sarabia Medina. I would like to just address, I appreciate the questions that have already been presented by the board or inquired of by the board. I would like to provide everybody just some background with respect to the events that involved the allegations involving my client's TikTok account. To answer, I hope, some of the questions that were posed, then Sergeant Sarabia created the account in question, the TikTok account, in and around March of 2022. At the time, he was a sergeant, and this was a social media platform on TikTok that he was utilizing. His intentions as the TikTok account garnered some traction and was creating a platform for him. His intentions were an attempt to bridge the gap between the community and law enforcement and the sheriff's department. He began posting TikToks in and around March of 2022. At some point in time, the sheriff's department did become aware of the platform, and he was approached, and this, I believe, was one of the questions. He was approached by a captain, but solely for the purpose of asking him to not put or place the department's intellectual property in his TikToks. He was asked to essentially cover that intellectual property. At the time that he was approached, the evidence in the sheriff's department's own investigation, which is what the Post utilized in their investigation, he then proceeded to ensure that videos, to the best of his ability, that the videos, TikToks on his account were covering the intellectual property. At no time at that time was he asked by a captain whether or not these TikToks were on duty or off duty, or whether or not, the times that they were either video recorded or posted. And he did, in fact, move forward. He covered the insignia or the intellectual property in the best fashion that he was aware of. And at the time, he was never approached again with questions up until the interview with Internal Affairs about being on duty or off duty. He did continue after that initial inquiry to continue to post so long as he was covering the intellectual property. We have information, the information in the investigation established that after the TikTok account was created, the sheriff's department and specialized unit with the sheriff's department was in fact monitoring Sergeant Sarabia's TikTok account. And one of the reasons we believe that was occurring was because he shared a TikTok during the election process involving then Sheriff Villanueva, and he was the incumbent, and his opposition, which is the current Sheriff Luna. And he shared a TikTok in support of then Sheriff Villanueva. And we have information that as a result of that, his TikToks were being recorded and were being tracked. At one point in time, he was approached again by his supervision, and he was offered a 3-day suspension for the displaying of department intellectual property. Sergeant Sarabia indicated at the time that he felt that that was excessive under the circumstance, because when given direction to conceal any intellectual property, he took that under advisement, and he immediately moved forward in doing that. And he felt that the 3-day suspension was excessive. And so he asked that instead he be issued a written reprimand. Following that, and very shortly after that, is when the department provided Sergeant Sarabia with the initial a notice of administrative investigation. That was on September 28th of 2022. And then he was then subsequently provided another amended notice of administrative investigation by the Sheriff's Department on 11/11 of 2022. And then he was placed on paid administrative leave on March 9th of 2023, and then issued another amended notice of investigation on May 11th of 2023. And then finally interviewed for the first time on June 8th of 2023, almost 8 months after he was initially notified that there would be an administrative investigation. At the time of the initial interview, Sergeant Sarabia did his best to recall times and dates that he either recorded TikToks at the police department or the station, and times and dates when he posted those TikToks. What's important for the board to keep in mind is Sergeant Sarabia did not learn about the specific TikToks he was going to be questioned about until he was in the midst of his interview. And at that time, he made it very clear that his practice with respect to recording TikToks at the station was to do it before he started his shift or after he completed his shift. He admitted being in uniform at times. He admitted that sometimes he was at the station, but his best recollection at the time, as he conveyed it, was that his practice was to make every effort not to do this on duty. And so the answers he provided in that interview almost 9 months after, or 8 months after being advised of this investigation, and a year to a year and a half in some instances of when he posted these TikToks, he did his best to provide answers that were truthful and concise to the best of his recollection. He was then subsequently interviewed again on July 14th of 2023, again, approximately 9 months after the original notice. And again, a year to a year and a half at that point, or almost a year and a half, since some of those TikToks had been actually posted, not necessarily recorded. And so the burden, as Post is aware, or the board is aware, is clear and convincing evidence. No clear and convincing evidence has been introduced to establish that going into this interview or in this interview, Sergeant Sarabia possessed the intent to deceive or be deceitful in his responses. Remember, going into this interview, Sergeant Sarabia was aware that the department's level of discipline that they had intended to impose against him almost 9 months prior was a 3-day suspension without pay. Lastly, I know I'm running out of time, or have run out. Ultimately, Sergeant Sarabia at the time of imposition of this discipline had a 16-year career, 7 of those as a sergeant, with no notable prior discipline referenced by the department, or even referenced, more importantly, by the investigators in this case. And he had excellent prior evaluations. There were no issues of credibility, integrity, or honesty, either as a deputy or as a sergeant. And so we believe in this case, the criteria has not been met with the clear and convincing standard, not just that is required here, but also that is required in order to sustain allegations of dishonesty.
Any questions?
I have one.
Sure. Mr. Johnson.
I believe you stated that he stated that these TikTok videos were to bridge the gap between the police and the community. Could you explain the video concerning the taser when the young man was running and he was tased and he kept flashing the taser beam consistently?
So I mean, I know specifically what you're referring to, but what you have to remember with respect to what is before the board here is an allegation of dishonesty. And so that is the criteria here. That's what we're here to address, are the allegations of dishonesty. There are no findings as I'm familiar with the board that involves the actual content of the TikToks or the content of the TikToks. I will tell you that Sergeant Sarabia posted numerous TikToks well beyond those that he was questioned about. However, I will tell you that he said in his interview, and he described the purpose behind the account and why he was posting these TikToks, and oftentimes would describe reasons for uses of force and how and why sometimes these things would occur. And so certainly I think, and I know he is present on this call, he may be able to provide you with more clarity with respect to that, sir. But I do know that he has expressed and expressed in his interview that his intentions at all times were not to disrespect or to present information that would be perceived or reviewed by someone as being disrespectful. However, his intentions at all times, he expressed, were to provide information, context, experiences that he felt would certainly bridge that gap. But he is on this call, and if you would like him to provide you with more context as to his intentions behind any of his TikToks, including that one, I'm sure he would be willing to do that.
I could just add something on to that point. I just want to bring attention to section 1209, which essentially says we can only address the issue of sufficiency of our findings during this hearing, right? And during the public comment period. Our findings are a finding of dishonesty by the peace officer during the internal affairs investigation. As counsel for Sergeant Sarabia has indicated, there are no allegations about the content of those videos. There's also an indication that his statements were only to help provide clarity. The division has found that that's not the case. The division has found that the dishonesty was clearly intended to cover up his misconduct. And what we need to decide here today is whether our findings were sufficient in the matter under 1209. So
I have a quick comment. Adding to what Mr. Johnson's question was, Board Member Calavo. I think his question was relevant to the honesty / dishonesty, because as community members sitting here on this board, I don't think anyone I know in the city of Sacramento, the county of Sacramento, would look at that video and see that it is bridging the gap of the community. So if Mr. Mr. Medina would like to explain and bring us on board on how that's bridging the gap in a community who are facing issues with law enforcement currently in California, I'm more than willing to listen.
Of course. Can you guys hear me okay?
Yes.
Right. Again, thank you again for listening to my case here today. To answer your question on that specific video, there's a caption that I put on top of the video, and that caption says, 50,000 votes, please fight us in court, not on the streets. And that's the message that I want to get out there. Like, do not fight police officers on the street. If you don't agree with what he's doing or saying at the time, do not fight him. Just fight us in court. I do agree that maybe arching the taser was a mistake looking back. But that's the caption that I put on the video, because that's the message that I want to get across to my viewers.
I have a question. Is it your position that none of the TikTok postings that were investigated were conducted on duty? And my second question was, there's some monetary reward or compensation for doing this?
Of course. So as to your, I see you're asking about whether or not there's a monetary compensation on the videos. The videos that I post are monetized. So basically, they do pay per view or per, I believe, per 1,000 views or 10,000 views. I really don't know the algorithm behind the TikTok algorithm, but they do pay a certain amount of money, which is not much. I believe a video that went viral, I got like $1.25. So this is not, life-changing money. But to answer your question, yes, they do pay per view or per 1,000 views, I believe. And what was your first question, sir?
My first question was, is it your position that none of the postings were done on, that were investigated, were done on duty?
So at the time, I believe that all those postings were not done on duty, which is why I stated, or I stated to Internal Affairs that that was my belief, and that's why I answered. Obviously, I didn't have the luxury that the department has to listen to radio traffic or to look at to slow down the videos and look at specific times. So obviously some of those videos did fall within the time that I was on duty. And of course, you know, knowing that now, of course, you know, I would have, had I known, I would have disclosed that. But at the time, I did not know that. And that's why I provided my statement with Internal Affairs.
Thank you. Any other
You're welcome.
questions?
I'd like to follow up on that point.
Glasser?
Mr. Sarabia, thank you for answering our questions. On that,
You're
on
welcome,
that,
sir.
point, so it appears from what we've seen that there were more than a few videos posted where the evidence is quite clear that you were on duty. And so I would just like to sort of reinforce Mr. Doyle's question, which is it still your contention that you didn't realize at the time of the IA interview that you had been on duty for some of these?
No, so I recorded the majority of my videos before my shift and after my shift. That's the message I was trying to get across to the internal affairs investigators. However, there were videos that I recorded on duty. A lot of those videos were never posted. Those videos were just for myself and for family members. However, it turns out that maybe some of those videos were ultimately posted at some point, and that's why it shows that I was on duty. I did record some videos on duty, as I said, but those videos, as far as I know, were never posted, and that was my idea when I went into to interview with Internal Affairs, and that's why I provided those statements.
Questions? Okay, thank you very much.
You're welcome, sir.
Okay, at this time, we will adjourn the meeting and go into closed session. Does the board have any comments? Would a board member care to make a motion?
Johnson, motion, decertification.
Okay, we have a motion to certify. Is there a second? Second is Mr. Glasser. Please take the roll.
Okay, Board Member Bushin. Board Member Clavo. Board Member Crawford. Board Member Doyle.
Yes.
Board Member Dudley. Board Member Glacier.
Aye.
Board Member Johnson.
Aye.
Board Member Lara.
Aye.
And Board Member Pena.
No.
5 yeses, 1 abstention, and 1 no.
Passes. Okay. Is there any other business?
Sure. So as this concludes our case proceedings for today, I just want to point your attention to future meeting dates before we adjourn. As I mentioned earlier in the administrative report this morning, we have a hearing scheduled for May 15th and 16th to be held here in West Sacramento. At this point, we're going to kind of hold that date, but keep you advised whether or not we have any appeals to hear cases on that date. We will, however, have cases for the July 24th, 25th hearing here in West Sacramento. And I also would like for you folks to put some additional dates on your calendar so that we can plan forward. October 16th, 17th. January 15th, 16th, 2025. January 15th, 16th, 2025.
15, 16?
Yes.
And the October one again?
October 16th, 17th, 2024. April 16th, 17th, 2025. 16, 17 of April. And again, these dates, which one? I'm sorry. Yeah, we'll send them out. I just wanted to make sure we made an announcement. Again, we'll hold 2 dates in case we have a number of hearings. As you know, we've only been holding hearings for a single day hearing because the number of cases haven't required 2 days. So to the extent that we can isolate it to a single day hearing, we will likely meet on the Thursday.
Question on the 15th and 16th is contingent on an appeal process? Or was it-
Correct. Correct. On the May dates?
Okay.
Yeah.
Yes.
Yeah. So when we send out a notice of intent to revoke, the officers have 30 days within which they can appeal. If they don't appeal, that's a default, and whatever the division's findings were and recommended discipline would take effect. So at this point, we have not received an appeal for that date.
How many notices went out?
We've had one that has gone out and we have another one that we're preparing to go out before that date. Any other questions about meeting dates? Any public comment about that? Okay. Concludes our business for today. Go ahead and announce adjournment at 3:35. You're okay. Just want to make sure for the record. We'll adjourn at 3:35. Thank you.